All right, good morning. This is a regularly scheduled meeting of Panel A. My name is Jamie Wright, and I'm the chair. Would staff please come forward and call the roll?
Dr. Bishop?
Here.
Dr. Hawkins?
Here.
Dr. Lewis?
Present.
Mr. Serrano-Sewell? Ms. Yaroslavsky?
Present.
Dr. Yip?
Here.
Ms. Wright?
Here.
We have a quorum.
Thank you. And joining me to my left is Judge Jacobs. Thank you for being here to help facilitate our oral arguments this morning.
Good morning.
Thank you. Before we do that, we're going to have the election of the panel chair and vice chair according to Business and Profession Code, Section 2008. Ms. Yaroslavsky?
May I move to maintain the hierarchy as we have in place currently?
Okay. Do we have a second?
Second.
Any discussion? No? Okay. All in favor?
Aye.
Any opposed? Thank you guys for seeing fit to elect me as chair again and Dr. Lewis as vice chair. So we're going to go on to our oral arguments. We have Dr. Atashu. All right.
Good morning, and can the folks who are here for Dr. Atashu please come forward? Good morning, we are on the record. We are here for oral argument on the non-adopted proposed decision.
Wait.
I'm sorry, Ms. Yang, do you need a few more minutes? All right, the court reporter needs a few minutes, and I've got a lot of feedback here. I don't know if it sounds like that out there. I'll move it a little further away.
Up here.
Yes, it sounds, I'm going to move it a little bit away. Is that better? All right, thank you. Ms. Yang, let us know when you're ready.
Thank you.
All right. Then good morning again. We are now on the record. We are here for oral argument on a non-adopted proposed decision in the matter of the statement of issues against David A. Atashru, applicant, before the Medical Board of California. It is OAH case number 2015-010768. And does this sound as loud out there as it does to me here? It doesn't sound too loud? All right. And the medical board case number is 800-2014-006588. My name is Beth Faber-Jacobs. I'm the administrative law judge assigned to hear this matter today, assigned to sit with the board and preside over oral argument. Today is October 29th, 2015. It's about 8:20 a.m. And may I have appearances starting with counsel for complainant?
Good morning, Your Honor. Deputy Attorney General Lawrence Mercer for the Medical Board.
Good morning.
Good morning, Your Honor. Robert Willoughby here on behalf of Dr. Atashru.
Good morning.
Good morning, Your Honor. My name is David Atashru.
Good morning, Doctor. And before we proceed, there's a few things I'd like to disclose about my background and my role in this proceeding. As you know, Mr. Mercer is in the Attorney General's office. I want to let the applicant know that I used to be in the Attorney General's office for many years before I became an administrative law judge. And for the last 20 of those years, I did represent the medical board. I have not, and I also met Mr. Mercer in connection with my having been a Deputy Attorney General. I have not spoken to anyone from the board regarding this case. I have not spoken to Mr. Mercer concerning it. I have a very limited role in this proceeding. I am not the decision maker. The board will be making the decision, the final decision in this matter. But if there are legal issues that arise, I will rule on those. I believe I can be fair and impartial and provide a fair process to all parties, and I have determined that there are no grounds for disqualification. Are the parties ready to proceed?
Yes, Your Honor.
We are, Your Honor.
All right. As you've been previously advised, each party will have 15 minutes to present its oral argument, and then each will have a 5-minute rebuttal. And if the applicant wishes to address the board personally as part of his argument, he can do so, but I would swear him in first. I will give, if each party would like, I'll give you a 2-minute notice before your 15 are up, unless either of you have a different request for time, and I'm happy to accommodate that. Either party have a different request?
No, Your Honor.
All right.
No, Your Honor.
All right, and then we will start with the applicant, Mr. Atashru, and his counsel. Thank you, sir. You may begin.
Thank you, Your Honor. Once again, my name is Robert Willoughby. Good morning, ladies and gentlemen. We're here today to discuss the application of Dr. Atashru following the board's non-adoption of the proposed decision. And Dr. Atashru is here to seek a probationary license. This is a young man who is at the crossroads of his professional career. And I must say, I've only been representing physicians for something like 18 years now, but I must say from my heart that I have rarely encountered a person who is of such high character as this gentleman sitting before me to my right. I can honestly say that he is an honest, caring person who has devoted a significant part of his life to community service, is someone who is very eager to learn, someone who is humble, and who's someone I believe is truly capable of remediation. I've known Dr. Atashru for over a year now through this process, and obviously this has been going on for over a year. At no time has he ever complained. He's under significant financial duress. He has a wife. He is working at Stanford. His wife is a nurse practitioner at Stanford. And so, to go to the merits of this, the legal definition of incompetence, and that is the claim of which we're discussing here today, is an elusive legal definition. The board retained an expert who felt very strongly that Dr. Atashru is not competent to practice medicine and is not he is too much of a threat to public safety to be offered a probationary license. When I looked at the cases that defined the term incompetence, it doesn't seem to be anything that resembles the kind of incidents that are at issue in this case. The cases that I saw involved physicians who injected medications that were dangerous to a patient, practicing medicine while intoxicated, failure to monitor a patient during surgery resulting in death, an unnecessary surgical procedure. Dr. Atashru was a resident in a plastic surgery program at the University of Kentucky, during which there were a handful of events, which I'll discuss. But I think it should be noted that during a residency, residents do make mistakes. They are evaluated. And in this case, the overwhelming majority of evaluations of Dr. Atashru were positive. The incidents that were involved in this case were first a statement to the mother of a young patient, a burn victim, a dog bite victim during Dr. Atashru's intern year. Dr. Atashru admits that he made a mistake by making a statement regarding papoosing the child to the mother. There was no patient harm as a result of this. Dr. Atashu did not make any kind of treatment plan outside the scope of his residency purview, but he did make an improper statement. He apologized, and he admits that that was improper. Later in his career, there is an email in his file relating to the evaluation of a breast abscess. Dr. Atashu expressed the concern that this might require surgery, requiring a senior physician to be called into the hospital on the night before Christmas, which caused the supervising attending physician to be upset. However, Dr. Atashu's concern was validated by the fact that that patient needed to go to surgery. There was another incident in which there was only a short handwritten note in one of Dr. Atashu's evaluations that refers to a handoff of a consult for a patient with free air. Dr. Atashu has explained that that handoff was not to a resident, as was indicated in the handwritten note, but was to a pulmonary fellow. Dr. Atashu was appropriately going up the chain of command. He had another surgery that he needed to attend to, and so he appropriately asked for the specialist, the pulmonary fellow, to be involved. There was a fourth incident in which a patient's hand was burned by unexpectedly hot water in an automatic sink in the emergency department. Dr. Atashu fully admits that he should not have left this patient attended. Of course, Dr. Atashu had no reason to believe that this water would become scalding hot. It was an automatic sink, and in fact, the University of Kentucky took responsibility for the temperature of the water. I want to really spend as little time as I can here today because I want to leave as much time as possible for you to meet Dr. Atashu and talk with Dr. Atashu. I think you'll find, as I have, that he is someone of exceptional character and honesty. At the hearing, Dr. Atashu had one expert, a non-paid expert, Dr. Andrew Polito, who is the former chairman of pediatric plastic surgery at the University of Kentucky. Dr. Polito now has cut back some of his hours, but he is still in active practice. And I must say that he is one of the most experienced and respected pediatric surgeons in the United States. Dr. Polito has personal experience evaluating Dr. Atashu. He stated that without a doubt in his mind, Dr. Atashu is competent to practice medicine. Dr. Atashu obviously had what can be conservatively termed as a personality conflict with an attending physician in the plastic surgery department at the University of Kentucky. That physician physically assaulted Dr. Atashu. He insulted him in front of others. He refused to work with him. This is obviously a very difficult situation for Dr. Atashu, and the board's expert took the position that Dr. Atashu should have grieved this situation. Unfortunately, Dr. Atashu, it's not in his personality to cause trouble. He always wants to work out situations. He did not grieve. He did not complain. He put his nose down and tried to work harder. I want to draw the board's attention to a few of the letters that stand out in Dr. Atashu's file. Exhibit E is a May 2014 letter from Dr. Rinker, who's one of the attending surgeons in the plastic surgery program at the University of Kentucky. Dr. Rinker gave his strongest recommendation for Dr. Atashu when Dr. Atashu was trying to reapply to the plastic surgery residency program at UC Davis. When I say reapply, He wanted to re-enter another plastic surgery program. Of course, Dr. Atashru could not re-enter that program without a medical license in the state of California. Exhibit 8 in the board's exhibits, pages AG 13 to 14, Dr. Iacono in the plastic surgery program called Dr. Atashru one of the most improved residents in that program's history. Dr. Atashru will freely admit that the second year of his plastic surgery program was a problem, a year in which he made mistakes, a year that he needed to improve. But I would submit that if you look at the evaluations closely and the letters that we have submitted, Dr. Atashru made great strides in his third year, and that he showed a readily available or a ready ability to improve his deficiencies. Exhibit V is a letter from Professor Carney, another very respected plastic surgeon at the University of Kentucky. Dr. Carney states that Dr. Atashru will be an excellent physician. Exhibit W is also a letter of recommendation to the UC Davis Plastic Surgery Residency Program by the chair of the UK Plastic Surgery Program, Dr. Vasquez. Dr. Vasquez also recommends Dr. Atashru to the program. I submit that these attendings would not recommend Dr. Atashru to these residency programs if they found Dr. Atashru to be incompetent to practice medicine. Finally, Exhibit A is a letter from Dr. Stewart, another attending at the University of Kentucky Plastic Surgery Program. This letter states quite clearly that Dr. Atashru is not incompetent and that none of the evaluations or the summative letter that was written upon Dr. Atashru's departure from the University of Kentucky should be interpreted as saying that Dr. Atashru is incompetent. I really want to let Dr. Atashru talk to you and address your questions. I just wanted to mention that in terms of remediation, Dr. Atashru, after leaving the University of Kentucky, has continued to work in medicine. He has been a researcher at Stanford. He has also volunteered in a program called Co-Pilots in Care, in which he volunteers his time to assist older adults at the end of life. He's been invited as a guest lecturer at UCSF as a result of his work in this project. While working as a researcher at Stanford, he is continually evaluated by plastic surgeons in that department who have also written positive reviews that are part of this file. Finally, he has also continued to take CME courses through MD Anderson, including courses on practice and communication and professionalism. In summary, we would like to request that Dr. Atashru be considered for a probationary license. We thank you for your time. We realize this was a great expense and amount of time that the board has spent on this, and again, we thank you.
It's my understanding that Dr. Atashru, you'd like to speak at this time? Then let me swear you in.
Okay.
If you please rise. Raise your right hand. Do you solemnly swear under penalty of perjury that the testimony you'll give today, the statements you'll make today, will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Please have a seat. And you have 2 minutes and 50 seconds left.
Sure. I know we only have a few minutes left, so I'll try and be brief. I'd like to again start off by just saying thank you. I know this is unusual, and I appreciate the board taking the time and the expense to come and give me the opportunity to speak. So my thanks. I'm grateful. And I do want to again acknowledge that my intention is to seek a probationary license so that I can re-enter residency training or at least supervised medical training. I'm not intending to practice independently. I want to go back into a supervised position to finish training, to improve and continue to improve my ability to practice. I will say that residency was at Kentucky. I encountered difficulties that I hadn't encountered before, but I believe even since then and since leaving, I've truly committed myself to rehabilitating and remediating and improving areas that I found I might be deficient in. I think this experience has been certainly one that sponsored reflection and self-reflection and was an exercise in humility. I believe I'm in a position now where, and especially in the time since I left Kentucky, I've spent time learning to improve my communication, improve my work with patients, and also dedicated myself to mindfulness and understanding boundaries and making sure that I know where the limits are and when to ask for help. So I respectfully submit that that's my intention, to go back to be able to be in a supervised position for training, and I think that I could rehabilitate, and I have remediated, and I'd be ready for that. If you look at my record, I have spent my whole life dedicated to helping people, from undergrad to medical school, and even into residency. I've dedicated myself to helping the underserved. That still remains true. My intention of getting a license is to one day be able to do the same for the people of California. Thank you.
Thank you. All right, if you'll give me 1 second, we'll reset the clock. Mr. Mercer.
Good morning, members of the board. I'm here to address what we agree is the single issue, that is whether the applicant should be granted the probationary license that he's requesting. I think that I'd like to take a moment and just clarify the role of the AG in these cases. There may be some misunderstanding that we're just hired guns, that when we get a statement of issues sent to us by the board, that our only goal is to get a license denial, and that's not the case. Our role, if we have one important function, is to bring forth the evidence and put together a full record for the administrative law judge and for yourselves. And we believe that this administrative record is contains more than ample evidence to support the decision, and for that reason we ask that the decision be adopted by you. I would like to clarify a couple of legal points at the outset, which were raised by Dr. Adeshru in his argument. And first off, we need to start with the decision. The decision did not find Dr. Adeshru to be guilty of incompetence. The decision found him to be guilty of unprofessional conduct. And as the board members are aware, we can and do place physicians on probation. We even revoke physicians for unprofessional conduct. That being said, I would suggest that we did, in fact, prove incompetence. What the incompetence was is not, as counsel stated, clearly set forth in any of the reported decisions, because we don't have any reported decisions on statements of issues involving competency. There just are none. And every case is based on its own facts. In this case, I would submit to you that incompetence was shown by the repeated failure to translate what was admittedly sound medical knowledge into practical experience in a clinical setting. To put it bluntly, Dr. Adeshru hit the wall in his residency. He was a great medical student. He did well on tests, but when it came to his residency program, he hit the wall. And if we look at the evidence, which is recited in the decision and which we've set forth in our own argument, it started in his first year with a letter of concern. It moved into his second year with a probation. He was given the extraordinary opportunity to repeat his second year, which is an expense and a time drain for a program director, but nevertheless, they hoped that he would be able to remediate, but he was not able to do so. In the end, they were compelled, despite the amount of time, energy, and money that they had spent on this resident to terminate him from the program and to issue the letter referred to by my colleague indicating that he was deficient in 4 of the 6 core competencies. And those competencies, as stated by the board's expert, involved all kinds of care that apply generally to every specialty, not just to plastic surgery. And that's important because, of course, what we're talking about here is he competent to practice as a physician having failed his plastic surgery program? And if we look at the cases, beginning with the Papoosing incident, we see a failure to do a complete evaluation. We see discussion of a treatment plan without consulting with the other members of the care team. And ultimately, a lot of confusion and upset on the part of the parents because they're being given conflicting reports. Even if you look at the most recent case, the last case, the straw that broke the camel's back for UK, you have a patient who presents with a wounded thumb, and Dr. Adeshu properly numbs the thumb, but then inexplicably leaves the patient in the room alone to wash out his own wound. Clearly, with a numb thumb, there is an opportunity for patient harm here, and patient harm did occur, and Dr. Pulido said, yes, there was patient harm as a result of this problem. Dr. Pulido said, yes, Dr. Adeshu made mistakes, and Dr. Adeshu here this morning says, I made mistakes. Our concern is that, yes, residents make mistakes, but they don't make the same ones over and over again. And we see the Papoosing incident followed by Dr. Wong's report that he was so busy debriding a wound that he was unaware that the mother was extremely upset with what was going on in that examining room. We spent a good deal of time setting forth all the facts of this case. I'm not going to dwell on them. I would like to turn my attention to what I think is the concern of the board here this morning, and that is the penalty. Is the penalty too harsh? We submit that the penalty is supported by the evidence. We submit that the penalty is in the public interest, but we also understand that we are here on a non-adopt. That means that at least some of the panel members are concerned that this is too harsh. And our response is that the board's concern has to be for the public in these cases. If the board, however, disagrees that Dr. Adeshu's continued practice would be a threat to the public safety, the board does have the option to grant him a probationary license. We pointed that out in our brief. We also pointed out that key to that probation would have to be a practice monitor who would be responsible for reporting to the board. We have probation inspectors who monitor probations. They are untrained. They are unable to follow closely every one of our licensees. It is necessary that a medical professional be involved in this and responsible for reporting to the board if that's the direction that the board chooses to go. And I think I'll leave it there. Thank you.
Thank you. If you'll just give me 1 minute, sir, I'll reset the timer. All right, Mr. Willoughby, you have 5 minutes.
Okay, thank you, Your Honor. Page 19 of the administrative law judge's decision discusses the legal conclusions, and I do believe within the category of unprofessional conduct, it is incompetence that was the basis of the decision. I really have nothing further to submit and would like to table any additional time so that Dr. Tasheru can either speak or respond to any questions that you all might have.
All right. Is there anything further, Dr. Attashru, you wish to say at this time?
At this time, I think I'd love to be able to answer any questions that the board may have regarding my case or my application. I think that's one of the things that, even from the get-go of my application, I submitted to the board when I applied. I would really love for you just to get a chance to meet me and talk to me and get a chance to hear my side of the story, or how I think I should be able to practice medicine safely and in the best interest of the public. And so if I can use that time to do that now, I would appreciate that.
Are there any questions from the board? Then, Doctor, yes. Dr. Lewis?
Good morning. I have quite a number of questions, so my panel members will have to bear with me. First question is for Dr. Attashru. Why did you not file a grievance to your superiors with your statements of this kind of conduct?
Dr. Lewis, it's a really good question, and I think about that quite a bit. I'll tell you, in the situation in the moment, what I did was I reached out to my upper-level residents and asked them for advice, and the unanimous response from my upper-level residents was, don't do that. Keep your head down, just push through, don't do that. You're going to rock the boat. Whenever you have an evaluation like that or have a meeting that's like that, just say, yes, sir, accept whatever they say, and don't do anything. The second thing is, at the end, when it got to a point where it was becoming untenable, I did go to my ACGME representative at Kentucky, the one that was in charge of the GME and the representative to the ACGME residency, and I told her what was going on. She then investigated it. I came back a week later, and she said she confirmed the allegations. And then I asked her, well, what should I do? Should I grieve? And she said, you can grieve, but it's not going to make a difference. And I think at that point, this is that person telling me it's not going to make a difference, and me realizing that if you've got a situation where you've got 5 faculty members and you're requiring all of them to be involved in training you, I knew I wasn't going to be able to get the training I needed.
Do we have that as submitted in the record? I don't remember that. Is there a document that says you did that?
Dr. Lewis, there's no document of that. I mean, I think it probably stands to bear that if I asked that ACGME rep, would she go on record of saying that? I don't think she would.
I do want to note that we have to stay within the confines
Yeah.
of the current record. We can't
So
look
it's not
for
in there,
additional
okay,
evidence.
sorry. I have a question for, let's see, who's my next question? For Mr. Mercer.
Good morning.
Good morning. There were conflicting statements you made, and I need clarification. I have written down here, you made a statement that we're looking at the guilt of unprofessional conduct, and then you segued into incompetence, and I'm a little troubled by those two statements. They're
apologize.
confusing to me.
I may not have been clear. Let me
No.
be clear. At the administrative hearing, we put on a case, and we asked the administrative law judge to find incompetence. He did not do so. My statement to find incompetence. My statement with regard to unprofessional conduct was to point out that the administrative law judge did find the applicant to be guilty of unprofessional conduct. My second statement with regard to unprofessional conduct is that it is our position that the administrative law judge should have found incompetence. The reason he should have found incompetence is because we have a resident who, despite multiple opportunities to remediate, was unable to do so, meaning that he was unable to translate book knowledge into sound clinical practice. If you look at the pediatric surgery letter that was issued in the middle of his PGY2, that letter states that despite apparently adequate medical knowledge, he was unable to identify appropriate facts and come up with a good differential diagnosis and a sound treatment plan. So yes, we believe that the ALJ should have found incompetence and that should have been grounds for discipline, and we believe that should be considered in your consideration of the penalty. We have serious concerns here, and I don't think that Dr. Adeshru is denying that.
I have one last question also of you. I think this was within the purview of the board. You said the board's expert, Dr. Nuovo, was involved in reviewing this case or opining on the case, but I'm not clear on what Dr. Nuovo actually reviewed, because I don't know if he reviewed just, statements from the professors, or did he review the cases in question? So can you clarify that for me, please?
I can clarify it. I would start off with pointing out that Dr. James Nuovo is the Associate Dean of the University of California, Davis Medical School. He has been involved in residency training and education for 30 years. He currently oversees 60 programs, 700 residents, of whom he stated he's remediating 5 to 10% at any given time. With that said, I'm sorry, could you repeat?
Yes, we know Dr. Nuovo very well
Okay.
and his expertise. My question is, what did he review? Because I don't see it in here, what
Thank
he
you.
reviewed.
He reviewed everything he was
Record.
given, which is everything that you have. He reviewed the entire application, which is everything that Dr. Adeshru felt was important for the board to know. He reviewed all of the documents from the University of Kentucky, which included all of the faculty evaluations. Now, those are important because who are the faculty? They are the designated ACGME reporters who are responsible for periodically evaluating Dr. Adeshru's progress. And that was what was the basis for his opinion that despite repeated opportunities to do so, he was unable to remediate.
But Mr. Mercer, did he review the cases that were in question that led to the charge of incompetence? Do you know if he did?
I believe what you're asking me is, did he review medical records?
Medical records of those patients that were involved in the alleged incidents that led to the incompetence charge?
And that brings us to the unique aspect of this case, as in all other applications where the applicant comes to us from another state, and that is that the board's subpoena power only applies to the state of California.
1 minute.
We will never have those records.
Thank you.
If there are any other questions there, yes, because the applicant still has another minute left. Yes, doctor.
Dr. Hawkins. Thank you. Dr. Adeshru, in the record, there's an indication that perhaps a medical diagnosis may have been a factor in some of the interactions. I don't know if you still believe that. I do have a question whether that condition, if it does exist, is being treated, and whether that was a factor or is a factor going forward.
Yes, Dr. Hawkins. I think with the rigor of residency training, I think all of us would know you have to be spot on. There's just no room for margin there. You have to be at your best. And so I, during residency, found that I had, I guess I should have known from being young, but I was able to compensate until residency ADHD and meibomianitis, 2 conditions that were treated in my second year of residency and made a drastic improvement in my third year. So those are currently being treated, and they help tremendously. The one, ADHD, and then the second, meibomianitis, being my eyes would dry out during residency. It makes it difficult to operate through your loops, so I switched that out with, now I operate only in my glasses. I got my prescription into my loops, and I use, it's a warm compress, opens up the tear ducts. It makes it easier for me, for my eyes not to dry out. And that addressed all those issues.
Any further questions? There's another minute left, if anyone. All right. Then with that, thank everyone. This matter is now under submission. The board will be meeting in executive session.
So we're going to go into closed session, so if everyone could leave the room, and we'll call you back in once we've completed our
right, are we ready to go on the record? Everyone ready? Then good morning. We are on the record. We are here for oral argument following a grant of reconsideration in the matter of the petition for reinstatement of a revoked certificate of Samantha Landy Liu before the Medical Board of California. It is OAH case number 2014-120985 and Medical Board file number 800-2014-003701. My name is Beth Faber-Jacobs. I'm an administrative law judge. I've been assigned to sit with the board today and preside over this matter during oral argument. Today is October 29th, 2015. It's about 9:25 a.m. Council, may I have appearances for the record, starting with the counsel for petitioner in this matter?
My name is Marvin Firestone, and I'm representing Samantha Liu, who's sitting next to me.
Good morning, sir, and good morning, Ms. Liu. And for the Attorney General's office?
Deputy Attorney General Lawrence Mercer for the Medical Board.
Good morning, Mr. Mercer. Before we proceed, there's some information I'd like to disclose about my background and my role in these proceedings. As you know, Mr. Mercer is in the Attorney General's office. I used to work in the Attorney General's office for many years before I became an administrative law judge. And during the last 20 of those years, I did represent the Medical Board. I was in the same section as Mr. Mercer, although we worked in different cities. I wanted petitioner to know that I've not spoken with anyone from the Attorney General's office or the Medical Board in this matter. And I have a limited role in this proceeding today. I am not here as the decision maker. I will be assisting the board, but the board will be making the decision in this matter. If legal issues arise, I will rule on those. I've determined that my familiarity with the Medical Board and the Attorney General's office is not grounds for disqualification, and I believe I can be fair and impartial, provide a fair and impartial proceeding today to all parties. But if there are any questions, I'm happy to answer that. Are the parties ready to proceed?
We are, Your Honor.
Yes, Your Honor.
All right. As you've all been previously advised, each party will have 15 minutes to present that party's oral argument and then 5 minutes for rebuttal. And if petitioner wishes to address the board personally as part of her argument, she can do that, but I will swear her in first, and her time will come from her oral argument side. And if the parties would like, I can give you a 2-minute notice or whatever amount of time you would like. Mr. Firestone, is 2 minutes fine, or would you like a little bit more?
2 minutes are fine.
All right, Mr. Mercer?
Also fine, Your Honor.
All right. Then starting with the petitioner, Mr. Firestone, you have 15 minutes. You may proceed.
Thank you, Your Honor. Good morning, Medical Board panel members. As I introduce myself, my name is Marvin Firestone, and I have the distinct honor and privilege of representing Samantha Liu with regards to this proceedings and before the Honorable Medical Board panel. I'd like to tell you a little bit about Samantha. Samantha was graduated from the UCSF residency in general psychiatry, and then was graduated from the fellowship program in child psychiatry. Soon after she completed this training program, she had a patient, a psychiatrist who was on probation with this Medical Board. He was diagnosed as having bipolar disorder. It so happens that Samantha also has a diagnosis of bipolar disorder. In 2004, soon after termination of treatment of this patient by Samantha, he came back to see her and was perceived by Samantha to be seductive and intimidating. Due to her inexperience, her poorly managed bipolar disorder at that time, and her problematic childhood upbringing, Samantha was unable to manage this patient's transference behavior towards her. It led to an affair for a 2-month period. She then behaved in a dishonest manner to cover up the egregious behavior on her part. Due to these unprofessional acts, Samantha's license was revoked by this board in 2007. The reconsideration case before the medical board right now involves denial of Samantha's petition for reinstatement of her medical license a couple months ago. Reinstatement is warranted because Samantha is honest and she's now rehabilitated and safe to practice medicine. Here are the reasons for reconsideration of the denial and why it's warranted. Number one, the decision unfairly punishes Samantha for the prior underlying offense, rather than giving a fair evaluation of the evidence presented of her present state and her rehabilitation. Number two, Samantha has met her burden to reinstate her medical license and has provided reliable evidence that she accomplished rehabilitation, she received the remedial learning that the board and society would expect in order to rehabilitate from the mistakes she made over 11 years ago. After all, it is unfair for this physician to continue to have a scarlet letter on her forehead. Number three, the legal reasoning and conclusion by the ALJ, the administrative law judge, that Samantha is dishonest are not supported by the evidence, are erroneous, and are inconsistent with society's goal of remediation. And number four, the findings and conclusions of the ALJ are based on a lack of consideration of all the relevant evidence, even substantial evidence of rehabilitation, and therefore the decision must be modified. Thomas J. Brady, MD, a board-certified child and adult psychiatrist and an addictionologist, served as an expert witness at the administrative hearing. He had no prior relationship with Samantha, did not know her prior to my retention of him to do a thorough independent evaluation of her. He did not receive the 2007 decision, but relied on his learning of the facts in the decision from interviews he had with Samantha, her consultants, and her care providers, as well as the summary of the decision which I provided Dr. Brady when he was retained by me. Douglas Anderson, MD, Samantha's treating psychiatrist, and Adam Travis, MD, who's Samantha's husband and sitting behind me, is a psychiatrist, chief of psychiatry at the Northern Region of Kaiser. Both these psychiatrists provided supportive statements for the ALJ's and the board's review. Despite evidence to the contrary, the ALJ opined incorrectly that, quote, the evidence showed the petitioner still is either confused or does not truly accept responsibility for what occurred, and the underlying dishonest conduct is not sufficiently acknowledged or addressed, end of quote. That's in the decision that you have received, paragraph 3, page 12. In seeking reinstatement of her medical license, Samantha was required to satisfy a demanding burden. And I submit to you that she has done so by clear and convincing evidence that she is rehabilitated. The board has received convincing evidence that establishes that Samantha is rehabilitated and is safe to practice. She has done what the board and the members of the public would demand of any licentiate who has lost his or her license and the trust of the public. She has taken steps to remediate the situation that led to her license revocation, including intensive psychotherapeutic treatment, board-approved medical record-keeping, professional boundary and ethics courses, and providing many hours of community service. She's made amends with her family and has kept current in her medical and psychiatric knowledge by attending many more hours of continuing medical education programs than are required of a licensed physician. Dr. Anderson, her treating psychiatrist, opined, and I quote, "Of particular note is her increasing maturity and sense of responsibility. She has more clearly seen her role in her difficulties that existed prior to the license removal. She has become increasingly humble, accepting of responsibility, and has learned a great deal about herself. Thus, today I see a much healthier and well-balanced Samantha Liu than ever before. I am confident that if allowed to regain her medical license, she will comport herself in a very professional and ethical manner. I ask the board to strongly consider allowing Samantha Liu to regain her license with whatever safeguards you deem necessary." End of quote. Professor Patricia Spire, MD, testified at the administrative hearing. She has been Samantha's ongoing mentor and consultant. Dr. Spire has known Samantha since she was a psychiatric resident and trained her as part of the fellowship in child and adolescent psychiatry. Dr. Spire also wrote about Samantha Liu, as I will quote, "Someone who is very bright and eager to learn, someone who is very naive, but someone who has and had a good heart." End of quote. Dr. Spire opined in her testimony at the administrative hearing that Samantha has made significant progress over the last several years. She stated, quote, "She came back with a renewed conviction that she could again become a psychiatrist, that she was fully rehabilitated. And after discussing with her at some length and reviewing things again, I felt that she was rehabilitated. In my professional opinion, Dr. Liu is fully rehabilitated, and she is able to practice medicine with a full understanding of her professional role and responsibilities. She has a deep intention to be a good physician, and she now really understands the boundaries that are required in practicing as a professional psychiatrist and responsible physician. And I have no hesitation that she will safely practice psychiatry in the future if her license is returned. She takes responsibility for her losing her professional boundaries, for her allowing herself to be intimidated, for her seeing herself as being coerced where it was not clear whether she was being coerced or not. She takes responsibility for the egregious breaches that she committed. She shows clear remorse for all of this." End of quote. I'd like to address Samantha's honesty. In light of Samantha's past dishonesty, the board is entitled to be exacting in its requirements as a proof of her rehabilitation with respect to honesty. I submit that Samantha has met this burden and testified honestly and consistently, as well as being honest with her treating and supervising psychiatrists, and with Dr. Brady, the expert who did the independent assessment of her. The ALJ made a critical error by ignoring Dr. Brady's opinions in his report and testimony. The totality of the evidence supports the fact that Samantha has demonstrated that she is no longer deserving of the adverse character judgment associated with the 2007 license revocation decision. It was assumed that Samantha was being dishonest because she described her relationship with her former patient differently at different times. The ALJ stated that the heart of this case is Samantha's honesty. Samantha has explained what was going on inside her head at the time that she initially felt that she was a victim and was trying to better understand how and why she misperceived the complicated relationship she had with the patient in 2004. The ALJ made an unfair assumption that Samantha was dishonest when she reported her past frame of mind, conflating it as a report of the findings of fact in the 2007 decision or as her current thinking. Samantha's description of her perception was taken out of context by the ALJ. Dr. Brady performed his initial examination of Samantha in November 2013, and again a week before the administrative hearing. Samantha sent an email to Dr. Brady shortly following her evaluation in November of 2013. Contrary to the finding in paragraph 23 of the ALJ's proposed decision, she was not taking a victim stance. She wrote to Dr. Brady in November 2013 as follows, quote, "Despite all said, I should not have let any of those incidents happen. Instead of seeing myself as a victim, I should have taken charge of the situation and handled the issues that were handed to me. Being the psychiatrist dealing with a mentally ill patient in this particular circumstance, I had the responsibility of keeping both my patient and myself safe first, and then getting the police to take the patient to a psychiatric emergency facility for evaluation in this case. I feel remorseful about my lack of responsibility and competency at that time due to my own psychiatric and psychological problems. After many years of therapy and rehabilitation, the mistake will never happen again." End of quote. Dr. Brady opined at the hearing before the ALJ, quote, "I have determined that she has done extensive rehabilitation work with a therapist, as well as an extensive amount of continuing education, consultation around issues of boundaries and ethics that she continues with at this time. Her mental status examination at the time of the interview in November 2013 and also my reevaluation last week showed her to have a normal mental status examination, normal thinking, no abnormalities found, a quite intelligent, articulate individual who has significant remorse over her ethical violation, and I concluded that she could operate as a psychiatrist safely with the public."
2 minutes, sir.
Thank you. Dr. Liu has gone through a transformation over the past 7-8 years, whereas before she saw herself victimized by her previous patient. And to me, that speaks to lack of responsibility for her actions. I see that that has reversed, and she has expressed a strong awareness of her violation. She's remorseful about it, that she has transgressed and gave up her power, so to speak, in this relationship with this mentally ill patient." End of quote. Dr. Brady opined that Samantha does see herself as responsible for what occurred. Dr. Brady opined in his written report, quote, "Dr. Liu recognizes the gravity of her ethical breach, is remorseful, and has worked diligently in a number of ways during the past several years to rehabilitate herself. I judge Dr. Liu safe to return to practice her specialty of adult and child psychiatry. There is a great need for Samantha's psychiatric services in an underserved patient population." End of quote. Samantha Liu speaks excellent English as well as Chinese. She is the one and only Chinese-speaking psychiatrist in the San Francisco Bay Area who is trained to treat children. She is active in the Chinese American community and would like to continue her career treating this underserved Chinese patient population. In conclusion, the mistakes Samantha Liu made nearly 11 years ago should not in and of themselves bar her from securing reinstatement of her license. She has met her burden of showing that she is rehabilitated. Disciplinary action is not intended to punish, but rather should be meted out with the goal of rehabilitation. Here, Samantha has spent the last 8 years accomplishing an excellent rehabilitation. Therefore, Samantha Liu, MD, respectfully requests the Honorable Medical Board to reconsider its decision and grant her reinstatement of her medical license so that she can resume her life's work as a child psychiatrist serving a much underserved patient population in California. Thank you for your attention.
Thank you, sir. All right, Mr. Mercer.
Thank you, Your Honor. I'd like to clarify the standard of review on this case. We've heard a lot about meting out discipline with an eye towards rehabilitation. That is simply not applicable to this case. Samantha Liu is not a licensed physician. She is a revoked physician. She is not a licensee, and the board does not have a duty to rehabilitate her. It is her obligation to come to this board fully rehabilitated. And I was just looking at a state bar decision. Unlike physicians whose cases go to the Superior Court, attorney discipline goes directly to our highest court, the Supreme Court. And the Supreme Court stated in Wetland versus State Bar, one who has been disbarred for acts involving a high degree of moral turpitude, which we certainly have here, and those committed by petitioner were of that character, should not be reinstated in the ranks of the legal profession except upon the most clear and convincing, nay, we will say upon the most overwhelming proof of reform, proof which we could with confidence lay before the world in justification of a judgment again installing him in the profession. I would submit that we simply don't have that here. This case is one of the most egregious cases I've ever seen, and both of the experts called by Samantha Liu called it egregious and horrifying. She embarked on a 2.5-month sexual relationship with a severely disturbed psychiatric patient, gratifying her own personal needs, and then when she became aware that her own license was at stake, she claimed that she had been repeatedly kidnapped and raped. Now, psychiatrists do occasionally commit that supreme sin of having sexual relations with a patient. And in most of those cases, the psychiatrist said, you know what, here's my license. I did it, there's nothing I can say about it. In this case, Samantha Liu forced the board through a full hearing, at which time she presented a defense that she suffered from Stockholm Syndrome and was a hostage much like Patty Hearst. After the hearing, she continued to see herself as being the victim. She filed a petition for reinstatement in 2012, and that was denied. That decision said, we don't have an objective evaluation here. So Samantha Liu went out to get an evaluation. However, it was not an objective evaluation. As the record makes abundantly clear, the critical document, the 2007 decision, which outlines all of her unethical and dishonest acts, was never given to the evaluator. At the hearing, he said, you're right, I've never seen this before. In his testimony, it became apparent that he was unaware of absolutely critical facts to finding out what exactly happened here, because you can't see how far someone has come until you find out where they came from. Past behavior is the best predictor of future conduct. And in this case, he was unaware that following the initial sexual encounter, which was not after termination, but was in fact the termination meeting with her patient, as stated in the decision, which is now the law in this case, she arranged to meet with the patient again the following day. And the day after, and the week after, and the weeks after that, she engaged in a voluntary sexual relationship with the patient, where she talked about their running away to Florida. She actually obtained a Florida medical license during the course of the affair with that intent. This is all set forth in the decision, and the evaluator had no idea. Instead, what did he get? He got an email, Exhibit 3, from Samantha Liu, which states, the patient suddenly showed up after termination to demand sex. Well, it wasn't after termination, and when the officers who were called by her husband came to the office, she said, no, this is a consensual sexual relationship. He also was not aware that when the officers showed up, there were empty ampules of nitrous oxide and marijuana cigarettes that had been imbibed during the office preparatory to the sexual encounter. She told Dr. Brady that she did what he wanted out of fear of retaliation. Again, no mention of the fact that they went to hotels, restaurants, they were in public places together on a consensual relationship. She did not tell Dr. Brady that when it became apparent that her own license was in jeopardy, she decided to accuse the patient of sexual abuse, kidnap, and rape. As a result, her own patient, her own former patient at that point, was charged with a crime. But her testimony was so inconsistent that the charges were dismissed. Now, in her statement to Dr. Brady, she said, "I was crying a lot and my testimony was inconsistent." This is hardly an admission that she perjured herself in a criminal trial. And finally, she stated, in order to sue me for money, he made up some stories and testified against me for the board. The board believed that patients are always right. You know, quite frankly, there's not even a veneer of rehabilitation here. There has been some rehearsed statements. She also called Dr. Spire, Patricia Spire, who is a reputable practitioner, but Dr. Spire was working from a different angle. She was not objective. She was working from a kind of therapeutic alliance, although she was a consultant. She did say that she assured Samantha Liu that she would be supportive. In fact, she was so supportive of Samantha Liu that when Samantha Liu went and got the transcripts of prior hearings to prepare her answers to questions at the hearing on her petition for reinstatement, they rehearsed her possible answers. There just wasn't a genuine showing of rehabilitation here, and certainly not the kind of rehabilitation that this board could place before the world in justification of reinstalling her in the profession. She violated her most sacred obligation to her patient by exploiting him for her personal interests, and contrary to her position that the board should not consider the underlying incident. In fact, the board is required to consider the underlying incident. Two factors that are set forth in 2307 are what are the underlying facts and what is her reputation for dishonesty. And both of them in this case are shocking and abysmal. Samantha Liu comes forward today and tells you that she has done extensive counseling. She's taken courses in boundaries and ethics. Our position is that ethics is not something that you can get from a course. You have it or you don't. You have a moral compass or you don't. As demonstrated by her November 2013 email, she continues to blame the patient. She continues to believe that the patient lied about her for money and to assist the board. This is not the kind of showing, not even close to the kind of showing that the board should be requiring. And I have not even touched upon the fact that she falsified her patient's chart to protect herself. I mean, this is mind-boggling. It really is. She had produced the chart in 2004 when she thought that the patient was under investigation. And then in 2005, when she realized she was under investigation, she came forward without any request and said, "Oh, here's his chart." And it contained 3 chart notes that she had simply written for the purposes of covering for herself. She didn't do a very good job because she accidentally dated them 2005 instead of 2004, which of course rang some alarms, and when the 2 charts were compared, it was clear that there had been some fabrication. But even today, in her statement in Exhibit 5, this is her email to Dr. Spire, she states that in the frantic rush to comply with the medical board, she negligently wrote up some notes. Well, that's not at all what happened. That's not even close to what happened. What happened was that she fabricated 3 chart notes relating to 3 meetings right before they began their sexual relationship to cover for herself. Again, I know I'm probably just repeating myself at this point, and I probably should just say there is no rehabilitation here. You really need to, after reconsideration, agree that the board the first time did the right thing and adopted the proposed decision. Thank you.
Thank you, sir. Give me one moment, and I will change the time here. All right, sir, you have 5 minutes.
Thank you, Your Honor. This board is not asked to rehabilitate Samantha. She has made tremendous efforts to accomplish rehabilitation, and I think she's done a good job in accomplishing that, according to those who know her best. Dr. Brady, actually, Mr. Mercer is criticizing all the experts that testified, Dr. Brady, Dr. Spire. Dr. Brady was fully aware of the facts of the 2007 decision. He interviewed Dr. Anderson, Samantha's psychotherapist and psychiatrist, who has known her from 2003 until the present. And Dr. Anderson shared all his understanding of what's transpired. Dr. Brady interviewed Professor Spire, who has known Samantha since her residency and fellowship all the way through to the present, and served as a consultant as well as a mentor to Samantha. Dr. Spire reviewed all the transcripts of all the testimony and the decisions with a fine-tooth comb so that she acquired a complete appreciation of the facts related to Samantha's situation so that she could better mentor her and be a consultant to her. Mr. Mercer is still arguing the facts of what occurred 11 years ago. She's been punished by losing her license. She is not the same person she was in 2004. Keep in mind she has taken extensive courses in ethics and professionalism and boundary issues. She has seen a psychiatrist in therapy sometimes 2 or 3 times a week, and she has continued counseling with Dr. Spire a couple of times a week for many years. She is a changed person, and it's not right to continue to see her with a scarlet letter on her forehead based on her egregious behavior 11 years ago. Thank you.
Thank you, sir. All right, Mr. Mercer, you have 5 minutes.
Thank you, Your Honor. I'll be brief. I'll just point out a couple of things that I think are important to your reconsideration, and that is that Samantha Liu, when she was practicing, was a psychiatrist. Psychiatrists, I think it's generally known, have access to the most vulnerable patients of our patient population. The protection of the public requires that you err on the side of the public and not on the side of the revoked physician. And certainly, and I think we tried to say this, and I'd like to say it again, the protection of the public is as much about the public's perception that it is being protected as it is about stopping wrongdoers. And quite frankly, it is our position that to reinstate Samantha Liu on this showing, on this inadequate showing, would undermine that confidence. The public would perceive that a physician could violate her most basic obligation to the patient not to exploit that patient for her personal gratification, and yet come back and simply recite some routine words of contrition and be reinstated to the profession. I don't believe, and I don't believe this board believes, that that's the kind of message that we want to send to the public. Thank you.
Thank you. Do any of the board members have any questions? Yes, Dr. Lewis.
Yes, hi, good morning. I have a question for Mr. Firestone. I'm looking at the ALJ's comments. It'll be paragraph 21, 22, 23, and 24 regarding the opinion of Dr. Brady. And you made a statement that Dr. Brady, and we can also say Dr. Anderson, the treating psychiatrist, received full disclosure of the board's decision. So I just want to ask you, is your statement based on knowledge from Dr. Liu, that Ms. Liu, that she gave him that information, both as psychiatrists, because the ALJ's statement is that that was not true. So I'm confused of the two. They're sort of opposing statements.
Yeah, let me clarify. That is a good question that I need to clarify. The actual written decision from 2007 had not been provided to Dr. Brady except in the administrative hearing itself. He was confronted with that and said that he was aware of the facts and did not change his opinion. He had received the facts underlying the 2007 decision from Samantha, from Dr. Anderson, and from Professor Spire. He interviewed both of those to get their understanding of the facts related to it, but the actual written decision was not provided to him in advance of the hearing.
So am I correct in assuming that Ms. Liu did not provide either of them the actual copy of the board's decision?
That's correct. This is an oversight on my part. I probably should have provided that rather than giving him a summary of the facts and have him interview the people who knew Samantha and get the information from Samantha herself.
Okay, thank you.
Mm-hmm.
Yes.
So are we to assume that Mrs. Liu is not going to have any comments?
I'm sorry, I didn't hear that.
Does Mrs. Liu have any comments at all?
If she would like to speak, I will swear her in, and there's about...
Yes, she would like to speak.
There's about 45
Yes.
seconds left. Then why don't we take this time and let me swear you in at this time. So, Ms. Liu, if you'll please rise. Raise your right hand. Do you solemnly swear under penalty of perjury that the statements you will give today will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, please have a seat, or you are also welcome to stand, whichever makes you more comfortable. And you've got about 45 seconds.
Thank you. Well, first I'd like to comment on Mr. Mercer, what he said about I did this for my gratification. That is entirely not true. I didn't get any gratification from what I did. Instead, it was suffering. I did not intend to do any of this. Just want to make that clear. Now I'm going to start my speech.
Well, you have just a little bit of time, so we'll give you a little latitude if the board wishes. Yes, you may proceed. Any objection, Mr. Mercer, to her speaking?
No, Your Honor.
All right, you may proceed.
Thank you for giving me this opportunity to be here. I regret that I made a series of mistakes over 11 years ago. This painful experience has been life-changing and vital for my growth. It gave me opportunities to learn, to understand more deeply about myself and my responsibilities as a physician. to appreciate more fully my wrongdoings and make sure they'll never happen again. This tragedy also forced me to confront my denial of a bipolar II disorder for many years. Reading the 2007 decision in retrospect, again and again, I can see that I was suffering from a manic or hypomanic episode of bipolar disorder. After that, I have finally received the proper treatment I needed. And my condition improved a lot. Now I look at the description from 2007, I couldn't recognize that I had done that. It's horrifying to me right now. Right now, I recognize that it's important to follow my psychiatrist's direction diligently in order to maintain my emotional stability. And because of that, my condition has been stable for at least over the last 5 years. Also, with the help from Dr. Anderson, I learned to deeply understand patients' feelings. Protecting patient safety is paramount. As Mr. Mercer has stated, I realized that my subjective memories contaminated with strong emotions during a time I was hypomanic affected my views of reality significantly. I have now been reviewing what happened before in a more objective point of view, and I can see how other people can see it very differently. In the Professional Boundaries and Ethics CME program, I have been able to formulate the psychodynamics that led to my boundary violations and develop an action plan to protect the patient and myself. Discussions among the peer group helped me feel supported while on the road of recovery. Maintenance and accountability seminars followed after the 3-day conference, helped me continuously learn from real-life cases from physicians all over the country. For the last at least 5 years, I have actively sought ongoing consultation and mentorship from Dr. Patricia Spire. She helped me understand my vulnerabilities and figure out the psychodynamics that led to my wrongdoings in 2004. We discussed transference and countertransference issues. She told me how my deeply ingrained traditional Chinese culture values had affected me in the way I perceived the 2004 incident, submitting to a demanding and intimidating male authoritarian figure because of fear may seem like coercion to me, but may not be in other people's views. I used to be weak and timid. Dr. Spire helped me to be stronger. I have worked extremely hard for 8 years to rehabilitate from mistake I made
Ms. Liu,
11 years ago.
Ms. Liu, we've given you a number of extra minutes. If you can wrap it up a little, maybe in 30 seconds or a minute.
Okay.
It's been about 5 minutes.
Okay. I believe I'm ready to return to serve the public without making similar mistakes. I want to make valuable contributions to community and society, Like I do at Red Cross now and more. I'm passionate about helping the underserved Chinese American immigrants and youth who otherwise have very few alternatives. Please give me the chance to show you that I can practice safely. I have worked diligently in hope to be able to practice medicine again with full integrity and high ethical standard. I promise you will not be disappointed. Thank you.
All right, in light of our having given the, Ms. Liu about 5 to 6 minutes to speak, Mr. Mercer, is there anything further that you need to say at this time?
No, Your Honor, I believe that what we said earlier covers the topics raised by Ms. Liu.
All right. Then at this time, the board will be meeting in closed session. We thank the parties. Before the parties leave, first, we are off the record. Before the parties leave, I have the court reporter form to give each counsel and the court reporter. Ms. Yang, how many pages were there? 32. All right. And I have about 10:10. What time did we begin opening argument on this? About 9:20?
9:20, yes.
All right. 1 second. I will just fill these out, give them to the parties, and then we will meet in closed session.
Always wanted to do this. It's what it's here for. It's what it's here for. Well, not always, but. Okay, good. Oh, good afternoon. I feel like it's morning. Okay. Good afternoon, everybody. I think we have everybody here. Okay, let me, this is the meeting of the Public Outreach, Education, and Wellness Committee of the Medical Board of California. So I want to first go over the ground rules. I know you've all heard these, the script before, but I'm going to read it again.
Move the mic away from your face, please.
Oh,
Move it away.
is that better?
Yes, thank you.
Such an echo in here.
That's good.
Okay, so here you go for the script. I want to ask all of you to please turn off your cell phones to silent or make sure they're off the table to avoid any feedback noise on our calls. You may notice board and committee members assessing their laptops during the meeting. They're using the laptops solely to access the board meeting materials that are in our electronic format, since we try to do paperless. This is an official meeting of the Medical Board of California, and as such, disruptions of the board's business will not be tolerated. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need of the board to conduct business, and should anyone disrupt the meeting, I will ask that person to conduct himself or herself in such a manner that permits the board to transact its business. Excuse me. This meeting will be available via teleconference, and individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by our teleconference moderator, who will be facilitating that process. For those members of the public participating via the teleconference, please wait until that moderator has introduced you before you make your comments. And also the volume of your, in the background needs to be turned down to avoid feedback. To request to make a comment during the public comment period, press the *1 and you will hear a tone indicating that you are in the queue for comment. If you change your mind and do not wish to make a comment, go ahead and press pound sign, and that cancels out the queue. Assistance is available throughout the teleconference meeting, and to request such assistance, press *0. Now, each person will be limited to 3 minutes for each agenda item. However, during the agenda item 2, which is public comment on items not on the agenda, the board has limited the public comment period for those individuals on the teleconference to 20 minutes. In addition, the public comment from individuals here at the meeting will also be limited to a total of 20 minutes. Thereafter 20 minutes, no further comments will be accepted. During public comment on any other agenda item, 10 minutes will be allowed from comments from individuals on the teleconference as well as those in this audience. And after 10 minutes, no further comments will be accepted. The business services staff here will be assisting me with receiving public comments via teleconference during this meeting. I'm almost done. The board welcomes public comment on any agenda item, and it board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget, I'm remiss in calling upon you for public comment, please, and you wish to speak, please raise your hand and I will recognize you. I would like to request that all speakers please complete a presenter slip so I can call you by name at the appropriate time, and a record is made at this meeting that can be full and complete. However, this is completely voluntary. Please give the speaker slips to Mrs. Simoes. Right? Right there? Okay. And I will do my best to call upon everyone who has supplied such a slip for the agenda item and recognize also those who wish to make a last-minute comment. I want to remind the speakers, please stay on the topic of the agenda item listed and keep your comments to 3 minutes or less, and we will have a timekeeping device, so when it goes yellow, please then try to summarize your comments prior to your expiration of your time. Thank you very much. Now we call roll of the committee members.
Dr. Hawkins? Here. Dr. Kraus?
Present.
Dr. Levine?
Here.
Ms. Pines?
Here.
Mr. Serrano-Sul? Ms. Yaroslavsky?
Present.
Dr. Lewis?
Present.
Thank you. We have a quorum.
We have a quorum. Thank you. So, the second item on the agenda is public comments not on the agenda. Is there anybody wishing to make a public comment in this agenda item?
Do you have slips there?
Well, I have slips. I just don't know. I gotta, wait a minute, let me sort them.
I'll do it.
I'm just trying to sort them. Hold on. This one doesn't have one. 4, 5, 4, 5. Now I have 2 that are not labeled. I have from Genevieve Clairvaux, and I have, do you wish to make a comment on this agenda item?
This is for something.
Okay. Good afternoon.
Good afternoon. Geneviève Claverol. I was kind of concerned of that little speech you gave just before the meeting, because at lunch you had a program on civility, and that's a big issue, and I think you are a wonderful board. You allow people to speak all the time, and it seems that to have that little speech before prevent, civility, and I think that's one thing we're having a lot of problem now. When you have a lack of civility, even impact the quality of diagnosis. And actually, I've done a lot of research on that lately, and I'd be more than glad to send it to you. But I am very concerned that at many of the meetings, not only yours, but the Board of Supervisors and so on, people are admonished to behave appropriately. And I think most people do. And I think to have that little speech don't help, that's all.
Thank you. Any comments, anybody else in the audience wishing to make comment on the agenda item number 2? Do we have any comments on the phone?
Amber, are there any callers?
No callers at this time.
Okay, no more comments on the phone. If not, let's move to our next agenda item. Next agenda item number 3 is approval of minutes from the July 30th, 2015 Education and Wellness Committee meeting.
So moved.
Second.
Second, okay. Should we,
Discussion on it.
any discussion on the minutes? Any discussion from anybody, the committee members? No? Any discussion from anybody in the audience on agenda item number 3? None? And anybody on the phone wishing to make a comment on agenda item number 3? Do we have anybody?
Amber, any callers on the phone?
No one on the phone.
None? Okay, Ms. Mose, please call the roll.
Dr. Hawkins?
Here.
This is to approve the minutes from the last meeting.
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Ms. Pines?
Aye.
Mr. Serrano Sewell? Ms. Yaroslavsky?
Aye.
Dr. Lewis?
Aye.
Thank you.
Okay, agenda item number 4. This is the presentation, discussion, and possible action of elements of a successful physician health program. Ms. Kirchmeier and Ms. Robinson, please come forward. Thank you.
Great. Good afternoon, Chair and members. Please turn to pages EDU 4-1 through EDU 4-23 for the PowerPoint presentation on elements of a successful physician health program. You may recall that I presented information on physician health programs at our July board meeting. At that same meeting, we had presentations from both the Colorado and Arizona programs. Board members expressed interest in continuing the discussion and asked staff to solicit feedback from interested parties. As you know, the board has not had a formal program since the diversion program was sunsetted in 2008. Board staff met with consumer groups and also with physicians groups to hear their recommendations for a successful physician health program. This PowerPoint presentation contains information on uniform standards, medical board staff recommendations, as well as consumer group and physician group recommendations and concerns. The purpose of this presentation is to provide information and discuss what elements are necessary in a physician health program in order for it to assist physicians with substance abuse problems while still meeting the board's mission of consumer protection. Any physician health program would need to comply with the uniform standards for substance abusing physicians and will require regulatory changes. As a way of background, 2008 SB 1441 Ridley Thomas created the Substance Abuse Coordination Committee charged with formulating uniform and specific standards that each healing arts board must use in dealing with substance abusing licensees, whether or not a board chooses to have a formal program. Currently, there are 16 standards. I will now go over some of them. Standard 2 specifies as requirements for temporary removal of the licensee from practice while undergoing a clinical diagnostic evaluation and specific criteria that must be met before permitting the return to practice on a full-time or part-time basis. The licensee must cease practice during the evaluation pending the results and review by board staff. While awaiting the results of the evaluation, the licensee shall be randomly drug tested at least twice per week and shall not return to practice until he or she has at least 30 days of negative drug tests. Standard 4 governs all aspects of required testing, which specifies the licensee can be drug tested at any time, with the minimum range for the number of random tests to be between 36 and 104 per year, depending on certain factors. It requires observed collection of specimens, and prior to vacation or absence, alternative drug testing locations must be approved by the board. Standard 6 states specific standards used in determining whether inpatient, outpatient, or other type of treatment is necessary. Standard 8 deals with the procedures to be followed when a licensee tests positive for a banned substance. The licensee must cease practice, and the board will contact the licensee and instruct him or her to leave work. The board will also notify the licensee's employer and work site monitor, if any, that the licensee may not work. Standard 9 specifies procedures to be followed when a licensee is confirmed to have ingested a banned substance. For instance, when a board confirms that a positive test is evident of use of a prohibited substance, the licensee has committed a major violation as defined, and consequences shall be imposed. Standard 10 specifies consequences for major and minor violations. In particular, it considers the use of a deferred prosecution stipulation in which the licensee admits to self-abuse of drugs or alcohol and surrenders his or her license. That agreement is deferred until or unless the licensee commits a major violation, in which case it is revived and the license is surrendered. Standard 13 provides that if a board uses a private sector vendor that provides services, that vendor must have standards for immediate reporting to the board, any and all non-compliance by providers or contractors that provide services such as specimen collectors, group meeting facilitators, and worksite monitors. They must also have standards to approve and discontinue the use of providers or contractors that fail to provide effective or timely services. And also standards for the licensee's termination from the program and referral to enforcement. Standard 14 states that if using a vendor to provide services, the board shall disclose the following information to the public for licensees who are participating in a board monitoring program, regardless of whether the licensee is a self-referral or a board referral. However, the disclosure shall not contain information that restrictions are a result of the licensee participating in a program. It must include the licensee's name, whether the licensee's practice is restricted or the license is on inactive status, and provide a detailed description of any restrictions imposed. Standard 15 specifies that if a vendor is to provide services, an external independent audit must be conducted every 3 years by a qualified independent reviewer or review team from outside the department with no real or apparent conflict of interest with the vendor providing the monitoring services. On a side note, the board thinks that there should be some type of repercussion to the vendor for a failed audit. Standard 16 provides there must be measurable criteria and standards to determine whether each board's method of dealing with substance abuse in licensees protects patients from harm and is effective in assisting its licensees in recovering from substance abuse in the long term. The board must use the following criteria to determine if its program protects patients from harm and is effective in assisting in recovery. All licensees who either enter a program or whose license was placed on probation as a result of a substance abuse problem, successfully completed either the program or the probation, or had his or her license to practice medicine revoked, surrendered, or placed on probation in a timely manner based on noncompliance with the program. And at least 75% of licensees who successfully completed a program or probation did not have any substantiated complaints related to the substance abuse for at least 5 years after completion.
And I just want to point out that the reason we went over these is because we need you to understand that we believe that any, first of all, because they're in Senate Bill 1441, which means they were part of the uniform standards, but because we want the members to understand these were the ones that were during the process, had brought up some issues and from different groups, and so we wanted to make sure that everyone knew that any program that we would support would make sure that they adhere to each one of these uniform standards. So unlike some of the boards right now who have diversion programs, and now these standards are coming in, if there was a program that was proposed, we would want this to actually be in from the get-go, right from the beginning, and it would require us to do some regulations. So that's why we wanted to go over those in depth, so you understand that there's a lot of safety measures and around those uniform standards.
I will now go through the board staff recommendations.
Before we go on, and I appreciate your going through this, I think it's helpful for all of us to remind ourselves of this. I had a question about the purpose, and I don't remember our deciding that if we were to have a physician health program, that its sole purpose would be to assist physicians with substance abuse problems.
I think, I guess that was kind of our thought behind a physician health program, that it would be doing that, but while enabling us to also meet our mission of consumer protection. And really, it's more to monitor, I would say, the individuals.
So again, I mean, my thought all along has been, when we use the term physician health, and it would encompass physicians with substance abuse problems, but would also be open and available to assist physicians with other issues that were they not addressed, had the potential to impair their function as physicians. The selection of the term health suggests something broader. And I understand that
I see what you're saying. Okay.
This purpose piece relates to whatever elements relate to a substance abusing physicians. But I'm just questioning whether we have said that is all that a physician health program would.
So actually, we'll get to that, because one of our board staff recommendations is that it is only for substance abuse issues. I think that you're possibly thinking it would also be for mental illness, or maybe disruptive physicians or things like that. And I think sometimes those are hard to monitor, but that is what's before the board. Again, when we go through these, I'm kind of superseding Letitia. It's okay, but I wanted to let you know that from our perspective, that was our thought. But when we go through the board staff recommendations, we want to hear from the board as well. And if you want to put other items in that, then that's fine for us. We would just put them in the, whatever you determine at the end. But from our perspective, we really wanted to focus on substance abusing licensees.
Dr. Kraus?
I agree with some of the concerns expressed by Dr. Levine. And indeed, when I've spoken to the issue before of a physician's health program, one of the things in my own community that I highlighted as representative of a need for that were 3 physicians in short time who had committed suicide. That, to my knowledge, none of them had a substance abuse issue. But there are things about the practice of medicine that causes physicians, more so than any other profession, to hide their problems for fear of having their business or practice infringed upon. Certainly substance abuse is high up on the list. But a physician who's suffering from depression will also hide that. And I think that we should not begin to use the term synonymously of physician health program and a substance abuse problem. So I would encourage the staff, if possible, to find some way semantically of separating those terms so we don't confuse them in the future, because I think there's a need for both.
And that's what we'll put in our recommendations when we get to them.
Okay, so board staff recommends the program should not reside within the board. It should be run by a private, contracted, nonprofit entity. It should have adequate protocols for the board's communication, for the program's communication with the board, and have regularly scheduled meetings. The program should allow for both self-referral and probationers to participate. Report to the board any physician who is terminated from the program for any reason. There shall be no diversion. If a complaint is received, the enforcement process will be followed. There should be clear and regular communication to the board on the status of probationers in the program, and participants should share in the cost of administering the program. If the required audit finds the program is not in compliance, there must be repercussions. There must be sufficient resources to perform clinical roles and case management roles with sufficient expertise and experience, not to exceed 50 physicians per case manager. The program should only be provided to substance abuse and licensees. This was our original recommendation based on what we discussed before. And strict documentation of monitoring is necessary. The following are some recommendations and concerns from the consumers group, which ask the question, is there a need for a program? And recommended an analysis be done to determine if there is a need for a program.
So before we get a little bit more into the consumer groups, I want to just explain our process when we went through this to put these together. And if I'm duplicating, I'm sorry. But we actually, as board staff, we sat down and first of all, we looked at the uniform standards, and then we looked at some of the other information literature that Ms. Robinson had found. And then we actually met with each group. We met with the consumers groups and we met with the licensee groups. And then the board staff recommendations are what we culled from all of the information that we got from those two groups. The items that are in your slides for the consumer group and for the professional groups, the licensee groups, are things that were outside of those. So things that we either didn't want to opine from and we wanted to hear from the board on them, or things that we didn't believe should be an element of a physician health program. So as we go through these, what we're asking you is to look at these and make a determination whether you think that they should be in a recommendation, because at the end of all of this, what we would like is to have a motion that any legislation that is moving forward would have the elements of what you have put together. And obviously you're going to make the recommendation to the full board when we meet this afternoon. But that's kind of what we're looking for here as we go through the consumer and the licensee side. Is there anything that needs to be added in? And if we didn't take it exactly as the group had provided it to us, we did put it in each of their slides. So as Letitia goes through these, we're not going to go through each one because you've all had a chance to read them, but the ones that we really wanted to point out that you need to kind of look at as the committee.
Okay, so I think the last one I have for the consumer groups is under certain circumstances, termination from the program should trigger revocation of the license. Some of the physician group recommendations were they felt that there should be an education and promotion of awareness of the program with information for hospitals, training programs, and medical groups about how to identify potential impairment, services available, policies and procedures, what to expect from the program, how to contact it, how to enter it, how to refer to it, and how to use it. They also felt the program should have adequate, stable funding, primarily from license fees, with additional funds from other sources, such as fees from participants, and that immunity from liability for those who function for the program. This concludes my report of elements of a successful physician health program. Now we'll turn it over to Kim.
And as you can see there were a lot of different recommendations that came out from each group. And so now we'd actually like to open it up to you to see if there's anything, kind of like Dr. Levine has already kicked us off in discussing, things that we have missed, things that you see in the recommendations from other group that we should add to our recommendations as a board to go forward, and then to answer any questions that you might have.
Mrs. Yaroslavsky, please.
So, excuse me, I have a couple questions. First of all, you asked consumer groups and you asked staff groups. I'm just wondering if there's any room to ask those providers of such programs if there are weaknesses or strengths that they see that to include within our regulations that might be helpful.
Absolutely, and just so you know, the licensee group that we met with were made up of not only licensees, but individuals who have these programs and that run these programs. So that was also involved in our licensee group. We had, I'm going to probably miss a bunch of them, but they were definitely there at the table, and they gave us a lot of really good input.
So the other thing I want to know is that as far as record keeping goes, when a licensee enters a program, there's records that are maintained. How long, when the licensee finishes the program, will records need to be maintained, and for how long, and is that part of a process?
That would be part of the process. I'm going to actually look to Ms. Robinson to see how long they were kept in the diversion when we had a prior program. So we'd have to have some record retention, and that would be set up in the administration of that vendor when they set that up. I'm not sure. We can also look at other state agencies and see how long they keep those records at that facility for those individuals. And obviously, if there was a successful completion and it was a self-referral, that would be nothing that then was reported. You know, the medical board would never have access to that because they'd be a self-referral in the program. And if they successfully completed in the amount of time that was required, then we would never have those records.
Right, okay.
Yeah.
Dr. Levine?
Yeah, so I guess I think I now understand where I might have been misreading this. And if what you're saying, and I think this is correct, is that this would establish the baseline for what has to be in a piece of legislation for a program, I'm going to leave the name aside, that addresses the issue of substance abusing licensees, that these elements would have to be in there. Whether the program went beyond that would not be addressed by this.
Right.
A legislator
Right.
could choose to do that, and what the board is focusing on is the specific issues of what needs to be in place to meet the requirements of the uniform standards and to meet the requirements of consumer protection in regards to substance abusing licensees.
Right.
And I'm fine with that. And my only hope would be that we not attach the name health to that, because I do think we have an interest in a concern for a broader set of issues to maintain a high-quality, healthy practitioner inventory, if you will, in California. And I would hope that any legislative effort to create such a program would go beyond the substance abusing physician licensees, but understand now what the intention of this is.
But I do think that if this board feels strongly about that, I think we should put that in as an element, because it's not just for substance abusing licensees if you want it to be more. So for example, in the physician group recommendations, there was one that recommended that it follow, and I can't find it right now, but it was that it follows the National Physician Health Program recommendations. Is on the next page.
Very last point. Second.
And the reason we put it in this slide rather than actually over in the board staff recommendations was because part of the recommendations and part of the standards that they have, they do take mental health individuals into the statewide physician health program. So if that's something that the board wants to do, a lot of these will fit into that category, because you'd still have probably a clinical diagnostic evaluation and some other monitoring that individual would have. And so that's not something we're opposed to if the board feels strongly about that.
Ms. Yaroslavsky, go ahead.
So just,
Oh,
I mean,
finish.
my sense is that there are many physicians for whom, knowing that there's a place they can call or a website or a contact they can make to get help, referral to some source of help, a triage function, whatever, whether or not the issue is a substance abuse issue, that it would be an incredibly useful thing. And again, may be tangential to this, but
Right. It was interesting, if I remember back to our old program, and again, I'll look to Ms. Robinson because she's much more experienced with it. If I remember right, a lot of the individuals who we had that were in our prior program with mental health issues also had substance abuse issues. They kind of ran hand in hand, if I remember right. I'm not saying that if a mental health person has a substance abuse, but it seemed that they came together a lot.
I just forgot one thing I wanted to ask you, and that was that within this floor that we're setting a bar at, that we're just saying that if any of our doctors go to a program, that we're like putting a stamp of approval on these programs, or we're not putting a stamp? Because if a doctor were to go to a program that's not given some kind of a stamp, and they are successful, that's their choice too, isn't it?
That is their choice, and they have that choice today. I think I'd like you to look at the board staff recommendations on this, similar to what Dr. Kraus has actually brought up as our policy compendium, that we would look at this in that any future legislation that were to come before the board seeking any type of a physician health program, whatever that looks like, that we would have something that we could look back at and say the committee and the board supports a program that would have these elements in it. And that's kind of what we were looking for today.
Sorry, thank you.
Right. Dr. Kraus.
I commend the board staff for the work product and work effort. There are three ways of doing things, my way, your way, and the right way. And as I keep rereading the consumer group recommendations and the physician group recommendations and the board staff recommendations, I'm wondering if you could help me figure out where the firm lines in the sand are, because I know not everyone will be satisfied.
We couldn't agree more, but by trying to put the board staff recommendations together, we really weighed, and I'll just walk through a couple just so you understand where we were coming from, and I'm sure there's going to be a ton of public comment, so I hope I don't step on anybody's toes when I talk about this. And I don't want to talk out of turn because we did have the groups there with us, and they'll come up and talk, but for example, the one big push about an analysis that needs to be completed to define if there is a program. We believe that is something that may or may not need to be done, but we believe that needs to be done as part of the legislation moving forward. If the legislator wants to take that on, he's going to have to deal with consumer groups coming forward to him, and he's going to have that. So that should be outside of the board. That's why we didn't put that in. The penalty, let's see, for the program, there's another one in here that was a tough one for us, and it's that you would terminate if there were issues with the program, with the vendor, in an audit, that we would immediately terminate the program. Now, while that sounds like the right thing to do, you have who knows how many, 100, 200, 300 individuals in the program. To immediately terminate them, that might not be the appropriate thing. And in some audits, obviously there's the possibility for improvement. And so we think that there should be repercussions to an audit where there were some negative findings, but we don't know that the best thing for physicians or for the public as well would be to immediately terminate that program and leave all of these individuals without an ability to be in a program. So there, where that fine line in the sand is probably going to be with any legislation that goes forward and what gets battled out in that arena, quite frankly.
Dr. Hawkins, did you have a comment?
Just that we want physicians who want to step forward and get help to do that, and just some acknowledgement. We have to develop a program that invites them, but at the same time doesn't put them in, even though we have to protect the public, it doesn't actually put them in a position where they're just less likely to come forward.
And that is one of the consumers group's concerns, is that if you attach it to the board, you might not get individuals that actually want to join into that program. And that was one thing we did hear from those groups, so.
Any other comments from members of the committee? If not, I'm going to go to the public comment of those individuals that are here in the room first. And I apologize, I'm just taking them as they came up, presented to me, and I hope I don't mispronounce anybody's name, but I might. The first one I have is Karen Mioto. Up to the public speakers table there on your right.
I commend the effort of the board, and as the chair of a medical staff well-being committee, I can't stress more the importance of addressing the mental health issues and finding an avenue where that can be dealt with, because as Dr. Kraus said, physicians feel very stigmatized by these issues, so I think it's so important in addition to the substance abuse issues. Thank you.
Thank you for your comment. And just remind the speakers, please state your name clearly, and if you'd like your affiliation, at least your names. The next speaker I have is...
Just a reminder that that is voluntary.
It is all voluntary. Yes, it's all voluntary. I have Greg, I think it's Skipper. Did I get that right? Yeah. Oh, good. Okay, thanks.
Thank you. Was I supposed to push a button or anything? No. Oh, it started by itself. Okay, so I'm Dr. Skipper. I am a board-certified internist and board-certified in addiction medicine, and I run the Promises Professionals Evaluation and Treatment Program in Santa Monica, California. And I've worked in addiction medicine for about 30-plus years. And during that time, I ran the physician health program for the Alabama Medical Board for 12 years prior to moving out to California a few years ago. So I've had a lot of experience in this area and have been involved in developing some of this, and I was at the meeting that the board invited us to. Thank you. I just wanted to point out one thing that caught my eye was under the purpose. It sort of implies that helping physicians is in conflict with protecting consumers. You know, sort of it says, while still meeting the board's mission of consumer protection. And I contend that helping physicians in itself can help, you know, patients. It helps protect patients. So I don't think we need to see them as either or. I think early intervention, getting help for physicians, having a healthier physician workforce helps patients. So there's no conflict. Another thing I wanted to point out is that there was a recommendation that the program, if it's created, have adequate professional staff. I certainly think that's totally appropriate. I think the program should have medical leadership by a physician and or physicians. That we should have, in this iteration, if it comes to pass, you know, MDs involved to be part of the program and part of the leadership to better, you know, communicate with the medical board and committees of the board. And I also want to make mention that having this program, unlike some of the other programs for other health professional boards, I think an emphasis should be on education and early detection and intervention, and rather than on just monitoring and probation, because you can have anybody sort of monitor people. I think the biggest helpful function to the public for public protection is having a way for example, hospitals to contact somebody and get some help with a colleague and sort of help them decide, should there be an intervention, how should it be done, and what should happen after that. So on the front end, I think we need a program that really educates and helps do early intervention, and rather than just worry about the monitoring part, which seems to be kind of the obsession of a lot of the previous programs and so forth. Anyway, thank you.
Thank you for your comment. The next speaker is Edward Barrera.
Hi, my name is Edward Barrera. I'm with Consumer Watchdog. I'll try to keep my comments focused because I know there's other people here who are much more, who know much more about this more in depthly than I do. But at the very least, first of all, we're not sure if you should be creating a program. But for us, any guiding principle for any program should be transparency, accountability, and independence. At a previous board meeting, you had some doctors from Arizona and Colorado testify about their state's programs to confidentially treat substance abusing doctors. Well, California's already had that for years. It allowed doctors caught using drugs to choose a confidential rehab program to avoid discipline. That was ended by the board because it became a revolving door for drunk and high physicians that prioritized keeping a doctor's addiction confidential over protecting patients. Medical boards should not sanction any program that lets doctors keep their addiction problems secret and avoid consequences when they fail. Once again, we're not sure if the board should be creating a program, but if they do, these need to be included. Patient safety should always trump physician confidentiality. Any complaint of possible substance abuse problems should be made a priority, and any enforcement should be handled expeditiously. If a patient is harmed, enforcement and disciplinary actions must happen. It should not ever be connected to the California Medical Association or anyone connected to previous diversion programs, and it also needs to be independent of this board. Thank you.
Thank you. The next speaker is Julie D'Angelo-Felmuth.
Good afternoon, Dr. Lewis, members. Julie D'Angelo-Felmuth from the Center for Public Interest Law. Excuse me, and I'm the former medical board enforcement monitor. As you know, this board had a diversion program for 27 years for substance abusing physicians. And after that program failed 5 performance audits, including one that I did in 2004, this board unanimously voted to terminate that program in 2007. Since then, physician organizations have attempted on many occasions to create a new program, some kind of program for substance abusing doctors. Each such program would be funded primarily by licensing fees collected by this board. Each of those attempts were different. Each of them failed. I would actively discourage you from going down this road again. You should learn from the history. There is no need for a new program. There are literally thousands of programs, treatment and monitoring programs in California and all over the United States, and nothing prevents any doctor from self-referring into one of them today. Also, the effectiveness of these programs has never been proven. No program tracks participants after they leave the program. Having said that, I'll tell you the elements we've insisted on since 2007. First, obviously, the program must strictly comply with the uniform standards. Second, doctors should not be able to participate in a medical board-funded program secretly. That's completely contrary to your mission. Only doctors who are on probation should be able to participate in any new program. Third, any and all program noncompliance should be reported to your enforcement program immediately. Fourth, a detailed program description and fiscal analysis must be prepared by the proponents. That has never been done, not even for the original prior program. Sixth, any new program must be audited by the Bureau of State Audits every 3 years, and if it is not performing well, it should be ended. Finally, under no circumstances should a new program be directed or controlled by the same organizations or individuals who were part of the liaison committee that oversaw this board's prior program. That has been attempted in the past. That is a non-starter for us. For many reasons, you should not go down this road again. You have other options. If you really think there's an insufficient number of private programs out there, or that they're not available in some locations, then look at that, study that, document that. If you think physicians need a referral to a good program, then task yourselves with coming up with standards and criteria for treatment and monitoring programs, and evaluate programs based on those criteria, and post a list of the good ones. If you think physicians don't go to treatment or monitoring programs because they can't afford them, and some physicians cannot, then create some kind of scholarship fund, perhaps with voluntary contributions, to help physicians who are truly intent on recovery go to a program. You should look into sources of funding other than physician licensing fees. But please don't think that your creation of a state-funded, state-subsidized program will lure in the many thousands of physicians who statistically have substance abuse problems. There were very few true self-referrals in your prior program. Because doctors knew they would probably relapse, they didn't want to come to a program connected to the medical board. That same thing will happen again.
Please conclude.
So, thank you. I encourage you to explore these other options. There is no need for you to create a new program. Thank you.
Thank you, Ms. Felmuth. Next speaker I have is Dr. Tracy Zemansky.
Hi, I'm Dr. Tracy Zemansky. I'm the current president of Pacific Assistance Group. We have 15 locations throughout California where we work privately with physicians who are in recovery. Most of us worked with physicians in recovery before the program was sunsetted by the medical board. I strongly support the board efforts to encourage physician wellness on every level. Any program that will be effective in preventing patient harm must have an early intervention and a self-referral option that is confidential and viable. Early intervention allows physicians who already find it quite difficult and challenging to ask for help to seek care before problems develop, which is the absolutely best way to ensure patient safety. As our excellent lunchtime speaker said, it is more effective to support positive values and action and be proactive than to correct a negative problem and be reactive. I strongly believe that patient safety equals physician early intervention and confidentiality, and support the medical board in developing and supporting a program. Thank you.
Thank you very much. Next speaker I have is William Coltern.
Howdy. I'm a physician and a diversion graduate of 16 years ago. And I am here to advocate for the redevelopment of diversion, which at a personal level certainly was very active in helping me direct my own life towards getting into recovery and staying in recovery successfully. And the one point that I wanted to make was, at least in my own experience, was that there are differences in programs, and that there are programs out there that that can and do have special programs for healthcare providers that more than adequately can work with physicians during that recovery period. And it's because of diversion in 1999 when I was in diversion that I was directed by the diversion board to programs that were very specifically aligned with impaired physicians. And I think it certainly contributed to my recovery and continued recovery. Thank you.
Thank you very much. The next speaker is Robert Herbst.
I'm Robert Herbst, a retired recovering ophthalmologist. And I don't know what you should do. I'm the last person who would know what you should do. But I am in favor of, and I'm happy to hear that the board is at least considering a board-supported recovery program for physicians. Or not a recovery program, but a health maintenance program, if you will. And the uniform standards are fairly rigorous. The things that, what I found is the previous health program that was discontinued helped me do things that I wouldn't do myself. They were the ones that introduced me to means of handling my problem, and they provided the monitoring, and that was a very definite necessity for me because I was self-willed, and I think monitoring is an important part of this. But the other emphasis I think that would be helpful would be, again, education at the hospital level for the well-being committees, and the fact that the board sends out an action letter every month. I think that at least in some of those there should be prominent, and maybe there already is, but if there were a program, prominent that should education what that program is, where it is, and make it easy to find so that these physicians know where to go. And as for me, I probably wouldn't be here today if it weren't for the past program, and I was very sorry to see it go out of existence. But thank you for allowing me to speak.
Thank you for your comments. The next speaker I have is Michelle Montserrat Ramos.
Good afternoon. My name is Michelle Montserrat Ramos. I'm here on behalf of Consumers Union Safe Patient Project. I first became familiar with this issue in 2007 when the failed, now terminated, confidential physician diversion program was up for sunset review. You may ask, why would such a confidential program be of interest to me? Well, my fiance, Lloyd Montserrat, died at the hands of a cocaine-addicted physician. Lloyd was a California political leader whose life was taken at 36 years old because his path crossed with a physician who had a problem with crack cocaine and had earned a long arrest record, all while he held a license to practice medicine in California. You see, I should have known that Lloyd's doctor had a drug problem, a long arrest record, and a long list of victims. That information should have been available to me when I checked Lloyd's doctor's profile before Lloyd entered the hospital. But guess what? That information was not available. Why was this information not available? Because there was a confidential program in place which allowed doctors to practice with issues with drugs and alcohol, and Lloyd, I, and California consumers were not allowed to know. We did not have the right to know that these physicians had such drug and alcohol problems. So Lloyd died, dead at 36, and Lloyd's doctor continues to practice. You call that consumer protection? I think not, and most Californians would agree with me. I stand here to tell you that we will not support any kind of program that is confidential. Kim was quoted this week stating that the medical board wants you to be an informed patient. In order for us to be informed patients, you cannot support any confidential programs of any kind. There is no way that we will support any program that is confidential. Our lives matter. Rehabilitation of the physician cannot come before Californians' lives. We took steps in 2007 to change that. Information on drug-addicted and alcohol-impaired physicians that the board is made aware of is now available to the public. Your predecessors terminated a confidential program stating to hide something from consumers, something so blatant, it's unconscionable today. How could each of you think that somehow it is the right thing to do now to hide something so unconscionable from consumers? The uniform standards have only been fully adopted and placed into regulations for 3 months now. It took fighting you years to get you to follow the law and place these standards into regulations. In dealing with substance abusing physicians, you must make the implementation of the uniform standards your top priority. You must give the uniform standards time to work before putting in place any new system that might interfere with them. There is nothing now preventing doctors from seeking such treatment with complete confidentiality. There is no need to create a special program that may interfere with oversight responsibilities of the board. As your physician predecessor stated...
Please conclude. You're well over.
Okay. The public now demands transparency. Why should doctors be protected in secrecy when consumer safety hangs in the balance? Again, it is time to now protect consumers. Our lives matter. No more confidential programs of any fashion under any name. Thank you.
Thank you. Next speaker I have is Yvonne Chung.
Good afternoon. My name is Yvonne Chung with the California Medical Association. CMA appreciates the board's efforts to study this important issue and bring forward input and comment from all stakeholders. We support the development of a statewide physician health program. California is currently one of a handful of states that does not have a physician health program. And physicians are one of the few licensed health professionals in California that do not have access to this type of statewide health program. We believe that the establishment of a physician health program is consistent with the board's mission of public protection and will increase patient safety by ensuring that impacted physicians are receiving coordinated treatment and monitoring services and that their recovery is appropriately supervised. Such a program should also encourage education, early intervention, and encourage physicians to address issues before they rise to the level of impacting patient care. We believe the physician health program principles developed by your staff provide an excellent starting point for the development of a robust and comprehensive program that will enhance the board's ability to protect patients and rehabilitate physicians to return them to safe and active practice. We urge your adoption of these recommendations and look forward to continuing to work with the board on this issue. Thank you.
Thank you. The next speaker is Genevieve Clavel. You pass? Okay. The next speaker is Bruce Olmscheid.
Thank you. My name is Dr. Bruce Olmscheid. I'm a family physician in private practice in Los Angeles. I frequently see patients with substance abuse issues. In addition, as a physician in recovery myself, I am occasionally, I guess perhaps rarely, approached by colleagues seeking advice or suggestions about where they can seek help for themselves or for colleagues, very much aware of their fears and concerns about needing to access a program where they can seek early intervention and help without the ramifications that were addressed that can affect their livelihood and practice. I fully support the board's efforts to put a formal physician health program in place and hope that it is a program that physicians will feel safe to access. I respectfully ask the board to give additional considerations to the ramifications of requiring public disclosure of the names of any physician, I didn't say that correctly, of any physician, all physicians who are receiving services and doing well through a monitoring program. A program that does have confidentiality where appropriate, with public disclosure where appropriate, will foster self-referral at the same time continuing to provide protection to consumers. A program that allows for confidential reporting to the board will allow the board to administer a program that effectively monitors physicians who are receiving treatment for substance abuse and doing well, at the same time providing protection for consumers. Thank you.
Thank you for your comments. The next speaker is Mr. Dwayne Rogers.
Good afternoon, Chairman and members of the committee. My name is Dr. Dwayne Rogers. I am a licensed psychotherapist, and I am the Pacific Assistance Group Area Administrator in San Diego County. I have 43 years of experience in substance abuse and 33 years experience in monitoring licensed health professionals. I fully support your efforts to develop a strong and accountable physician health program. I believe California deserves such a program and that licensed physicians in California deserve this program. I have monitored physicians and other licensed health professionals since 1982 and continue today to monitor licensed health professionals from the 6 other boards. I have personally monitored over 590 physicians and health professionals in support groups over that time and have found that with early intervention and monitoring, physicians in recovery enhance the quality of their patient care. I am aware of 2 studies, one in 1991 and one in 1993, that found that physicians in a monitored program had a lower incidence of license complaints than the average licensed physician in the state. The concept of not monitoring at-risk physicians through random and observed urine tests, weekly support group meetings, case management oversight, and site monitor reporting is dangerous itself. I have monitored physicians in both state and private programs. I find that a strong structure with leverage, support, and monitoring can, in either case, provide a safe environment for physicians to seek help before more severe problems develop. This is a more effective alternative than enforcement only. I would like to just say in support of a strong program with early intervention and self-referrals that my first diversion group in 1982 had 9 older male late-stage alcoholics and drug addicts. By 1980, the program and the group had a self-referral rate of 67%. I believe, my point is that I believe that a confidential physician health program can achieve high levels of self-referral rates and thus early intervention before serious problems occur. Thank you for this opportunity.
Thank you very much. Next speaker is Dr. Zucker.
Good afternoon. My name is Michael Sutcher, and it's a pleasure to be before you again. I was here in July speaking about the Arizona Medical Board's Physician Health Program, which I have been the medical director of for 23 years. I would like to tell you that we started out with substance abuse as the primary focus and co-occurring mental illness, but for the last 6 or 7 years, we cover every area of physician health. I also have been actively involved in physician health activities in California for about a decade, and we run a private evaluation and monitoring program called the California Physicians Health Program. And in addition to working with and advising this board and staff, we've also worked with many medical groups, hospitals, and individual physicians in the time we've been here. I do have to make a comment about the gentleman from Consumer Watchdog in Arizona. Every single physician in our program is known to the board, and in fact, we monitor agreements written with the board's agreements that we oversee and monitor. They also are required to notify hospitals, surgery centers, and all employers, and any other party who has a need to know. So there is no one in our program unknown to the medical board. I also want to make a comment about self-referrals. What's commonly called self-referrals in this business are generally not true in the context, oh, I think I have a problem, I'll go get help. Virtually everybody gets a shove from a family member, a colleague, law enforcement, the board, or other sources to get help. So it's not realistic to think that people will just go get help on their own. This board and a physician health program can play a key role in doing that. I do think, in echoing Dr. Skipper's thoughts, that we do need strong medical leadership. That was something that was seriously lacking in the prior diversion program. There was also a comment about what happens after 5 years and record retention. We never throw our records away. We do get some people who come back, and it's nice to have those records 10 or 15 years later, because sometimes their memory of what happened isn't quite the same as what we recollect. And Dr. Skipper, Dr. DuPont, and McClellan, who wrote the original blueprint study that verifies the quality outcomes of a well-run physician health program, which was preceded by good treatment, are doing a research study nationally, which we are also participating in, on outcomes after 5 years, which preliminary data is extremely good. I would like to tell you I strongly support the effort you guys are undertaking. I agree with the staff recommendations that you heard today. I would comment that there's a comment that it's a nonprofit, has to be a nonprofit. I think it has to be well-run, regardless of the business structure. And I believe it would vastly help the status of consumer protection and public protection, and you in fulfilling your role by doing this. I think this state has been left short in the last 9 years or 8 years since diversion closed.
Please continue.
And thank you very much.
Thank you very much. And the next speaker is Lisa McGiffert.
Good afternoon. My name is Lisa McGiffert. I'm the director of the Consumers Union Safe Patient Project, and I'll try not to repeat, but we are among the people who believe that this program is not needed, and we strongly support the staff recommendation that if this program were to be set up, that there would be public information about physicians that were referred to this program because of probation. We do believe that physicians are probably among the people in our culture who have the most resources for getting treatment, and we support them to get treatment. But if they come to the attention of the board because of some problem, especially of harming patients, then that should be publicly, and the board decides to act on that, that should be public knowledge. You just heard somebody recommend that the hospitals should know, the insurers should know, the employers should know, but the very people who need to know, the patients, are not on that list, and we think that they should be able to see that. A couple of other things on the recommendations, one of them to report to the board any physician who is terminated for the program for any reason. We think that should be a notice to the board for any physician who has violated the terms of the program. And with regard to the audits, we also think if there's an audit, that the program fails the audit, that is, they show that they're not responding to violations of what the physician is supposed to be doing, that there should be repercussions, and we think they should be serious, that it should be terminated. If the audits are every 3 years, then as soon as there's an audit that shows that a program is not performing as it should be, then that contract, that no more physicians should be referred to that program. The board should find another program to take that on. And I think that's really warranted considering that the program in this state 5 times had a bad audit. That should never happen again. First bad audit, go find another program. Thank you very much.
Thank you for your comments. That is the last speaker for the public comment from the audience. Now I'd like to ask if there's any public comment on the telephone.
Yes, we do have 2 comments.
Okay. Go ahead.
Can you hear me?
We can hear you.
Okay. My name is Tina Manassian. I was a victim of a doctor who participated in the former diversion program run by the Medical Board of California. I wasn't his only victim. There are countless others that suffered and have passed away. In 2002, he performed a surgery on me that I was not a candidate for. 13 years later, I still suffer from the lingering effects of the surgery, with excruciating pain and spitting sutures. During that time, he was at his all-time high with his alcohol problem, and the medical board was trying to revoke his license, but I didn't know any of this. He was in a secret and dangerous program called diversion. The issue was he failed diversion twice, but they allowed him to continue to practice medicine. The diversion program was a monitoring program. When the medical board becomes aware of a substance abuse problem in a physician, they divert the physician into a program as opposed to take away his license. The idea is to get them into recovery, rehab them, and put them back into practice when he's safe to practice. And during that time period, they're supposed to monitor him, do random drug testing, attend group meetings, and have worksite monitors when they're permitted to return back to practice. They use a lot of monitoring mechanisms in that program in an attempt to monitor the physician's behavior. The problem is none of those monitoring mechanisms were effective at all. They were inadequate. The random drug testing was not random at all. It was done at many times on the days the physician could anticipate or manipulate. In my case, my doctor was allowed to have his own office manager, an employee of his, a person he can hire and fire to be his worksite monitor. She lied for him on his AA records, stating he attended meetings, when in fact he never did. And they tried to dilute his urine when he was being drug tested. The medical board's diversion program was a failed program. It was audited 5 times, and they failed all 5 audits. I will not support any kind of program that keeps doctors' substance abuse problem confidential from patients. Think about it. If it was your mother, father, brother, sister, daughter, son, grandchild, would you allow them to be treated by a doctor who has a confidential substance abuse problem? Thank you.
Thank you for your comments. Is there anybody else on the telephone wishes to make a comment?
We will take our next one.
Okay, go ahead.
My name is Carol Moss. Can you hear me?
Maybe you need to speak up just a little bit or turn up the volume.
Okay.
Try again.
Okay. My name is Carol Moss, and I'm calling representing the public. Everyone believes that physicians, just like others, deserve care, and they deserve a chance to get better. But in this case, we know the California Medical Board has been unable to monitor and protect the public from harm with the diversion program, now called the Physician Health Program. No matter what you call it, the risk is far too great. If there is any kind of a health program, the public that we represent will not support this board managing confidential programs going forward. We know too many people that have been harmed. The risk is too great, and you will hear from many if you move forward with this proposal. Thank you.
Thank you for your comment. Do we have anybody else on the telephone?
Yes, we do.
Okay, we have somebody else. Go ahead.
Hi, this is Susan Shanese. Can you hear me okay?
Yes, we can hear you okay.
Thank you. I'm with Consumers Union Safe Patient Project,
and also medical error transparency plan. And I believe this is a conflict of interest to have any board physician or any member of the board that works with physicians, either directly or indirectly, vote on a diversion program of any type, with any title. And I would ask that you would remove yourself from this vote, as you cannot be impartial. I think this needs to be a public-only vote. Thank you for your time.
Thank you. Is there any other, anybody else on the telephone wishing to make comment?
Any other callers?
There are no further comments.
There are no further comments. Thank you. Have I failed to recognize anybody else in the audience here for public comment? Okay. Any comments from the board members?
I apologize. I have been sitting here listening to all of the public comments and to staff comments, and somewhere there has been a translation problem from English to English. We are sitting here with the opportunity of ensuring that whatever program is out there that exists is going to have certain criteria that is going to be helpful to protect the public and engage the people that are participatory. We're not here in any sense or fashion to create a program where doctors can go and use it to get help with substance abuse. So I think that the public needs to understand, and I just want to make sure I'm at the right meeting, because when I'm sitting here listening to everybody I've been listening to, I'm thinking, oh, well, we're starting a program, we're going to open the doors and start working. The uniform standards were adopted by every single health provider board in the state, except for this board. Wasn't it? Isn't that what happened in the back when, after diversion? Okay, then I apologize. So, but I just want to make sure that nobody sitting in this room assumes that we're going to be opening a program tomorrow, that the medical board is going to be running it and staffing it. Correct? Am I correct? I just make sure that we're all in the same place, because that's not what I was feeling. So I apologize for comments at the end, but I was starting to get nervous that we were going to be doing something that I was totally against.
Okay. Dr. Kraus, please.
May I move that our committee accept and endorse the board staff recommendations to be forwarded to the full board?
Do I have a second?
I'll second that.
Shrosowski is second. Any further discussion? Mrs. Simoes, do you like to call the roll?
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Ms. Pines?
Aye.
Ms. Yaroslavsky?
Aye.
Dr. Lewis?
Aye. The motion,
Just point of clarification that when the presentation is made to the full board, it be made with the clarity that this is not about the framework for the board to create a physician health program. It is to respond to work groups over a number of years that have asked the question, what would it take for a legislative proposal to be consistent with the board's needs for consumer protection? And this is staff's recommendations, having listened to that this, whether or not there is a legislative proposal or someone comes forward with one, that this is the beginning of that conversation.
correct, it's nothing to do with a legislative proposal. It's only if one was put forth by someone, this is what the framework that we would require suggests,
that we would
correct?
use to evaluate any legislative
Right.
proposal. Is that, I hope I'm
Kirschmeyer, that's
understanding.
correct. That's what I thought. I think we all have it. Okay, so the motion carries. Thank you. Okay. We have a next discussion is agenda item number 5. It's entitled Presentation and Discussion and Possible Action of a Verify License Campaign and a Public Outreach Plan. And we have Ms. Kirschmeyer, Ms. Smoes, and Ms. Hawkins.
Yes, today, tomorrow.
We will try to be brief. I know we're short on time, but this is actually an item, as we go through, the main intention of providing the whole outreach plan for us is that to gain information from the board members if we're missing anything in this plan. So as I go through my items and as Ms. Simoes and Ms. Hawkinson do the same, we're really looking for you all to provide input and specific input of places where you'd like this changed, or specific input as to other groups you'd want us to reach out to along the path of this. So on pages EDU 5-1 to 5-4, you will find the board's Verify a License campaign outreach plan. I'd like to start actually by thanking Ms. Pines for her assistance with this plan, and she has actually provided some great insight to staff, and we want to thank her for all her guidance. As you can see in the plan, although the board will continue with its current outreach, it will also be driving a broader agenda with an end result of making March Verify a License Month. Board staff will continue with its outreach from now until March, including attending events such as health fairs, health-related walks, and outreach at malls. I would like to take a moment and let you know how successful our 2 mall outreach events have been. Last weekend, we were allowed to set up in the mall in Sacramento. This event was advertised in 10 media sources, including newspapers, business journals, the Capital Morning Report, and CBS News. Board staff handed out brochures on how to verify your physician's license and also had computers set up to walk individuals through the board's website to look up their physician. In addition, staff are currently, actually right now, I think, probably getting ready to leave, at Horton Plaza and will be at Fashion Valley Mall tomorrow. We've also had some press coverage on this event too. Due to the governor's travel restrictions, we are running these events with the board meeting in order to use the staff that will be at the meeting to host those events. I would like to point out that we still do have travel restrictions particular to outreach. Therefore, we will be using staff in our probation units located around the state, as well as reaching out to board members to assist us with events as time permits. And with that, I'm going to kick it off to Cassandra to talk a little bit about the advertising.
There's a number of avenues that we're looking to utilize for advertising. One is Pandora, Pandora Radio. We're looking at mass transit, RT, and the other mass transit bus places in Los Angeles and Bay Area and situations like that. Utility bills, looking at possibly putting some advertising in utility bills. Store receipts, many stores give you receipts, and on the back there's advertising. Billboards, jumbotrons. In fact, we're in discussion with Sacramento Kings with regards to that. Radio PSAs and television PSAs as well. And I'm going to turn it back over to Kim because most of these require a budget.
So while the board may actually have the funding for some of this advertising, all funds expended do have to be approved through the Department of Consumer Affairs. I've spoken with DCA executive staff and informed them of the importance of the board's outreach. However, we may be limited in what advertising will be approved for this plan. We were able to do on another item that Cassandra had worked on for the prescribing PSA, we were able to expend funds for that, but we were kind of told that might be the end of our ability to do this. So this is something we will be having to talk to the Department of Consumer Affairs in order to get approval on those kind of advertising that costs money to do.
Okay, so I'm going to talk a little bit about the advertising that we've identified that is free. So this is something that we can do without DCA approval. So we've thought about, we've developed some posters that are similar to our brochures and that we could place at places like pharmacies or places where consumers receive health care, schools, other government agencies, libraries, and other other agencies were basically Patients Go. And we also want to talk to our sister state agencies about getting ads placed, like one possibility is on the employee pay stubs. And there's other agencies that actually do this now, that put advertisements on pay stubs. And we've also talked to some of the school districts about getting information in their electronic newsletters to parents, and we just have to kind of work with these other agencies to see what kind of advertisement placement we can get.
I'm going to talk about media distribution. I have a relationship with iHeartRadio. I did a radio show with them that was webcast on the prescription drug abuse and misuse issue, and I hope to go ahead and talk with them and schedule something with regards to Verify License as well. I'm also looking to reach out to National Public Radio and Capital Public Radio, and of course I always reach out to other media outlets. We have had stories done here from 10 News as well as Channel 7, NBC News, which had actually come out to the mall yesterday and interviewed me and filmed what we were doing there with regards to reaching out to consumers. In addition, there is an article that I believe is coming out tomorrow through the San Francisco Chronicle, and they also came out to the mall in Sacramento with me, took some pictures, actually took a lot of pictures, kind of hung out with us for about an hour to see what we were doing there. So this is something in addition that we will be pushing and moving forward to as well, and creating activities and things that can draw media coverage.
So board staff will be working on products that can be used to promote the board. We've actually already developed a brochure, which was actually approved by our editorial committee and printed by the Department of Consumer Affairs. Each of you have been provided with a copy of that brochure, I think. And in addition, DCA assisted in the development of posters based upon the brochure that the board can use. Board staff will be creating a PSA video that emphasizes the importance of checking the board's website to verify their physician is licensed and in good standing with the board, and a tutorial that walks the individuals through verifying a physician's license, as well as educates the individual on the board's documents and posting requirements. After the board meeting, these two items will be made a high priority. The board will need to work with the Department of Consumer Affairs to develop the PSA video, as we did with the prescribing video that we did. As you can see from the plan, there is a lot to be done. Board staff have thought about what needs to be done on the campaign, but we would like to know if the board has any suggestions for the plan or any questions.
Okay, I'd like to open up to members of the committee. Ms. Yaroslavsky first.
The other end if you want.
Oh, I started. Are you going to defer
No, I'm
to you? Okay.
never miss
Not
an
to yield?
opportunity to miss an opportunity. I want to thank you for all the work that you've put into this. I just would hope that when you're looking at the big scale of the situation, we've got 30 million people or 25 million people in the state of California, and reaching them 100 at a time is not really as effective a use of time as might be. So that if you were to take a look at the large hanging fruit, elected officials all have newsletters. They've offered, when we did our day at the Capitol, they've all offered to do it. So if you have a targeted date that you're looking to have this done at, instead of piecemeal as it comes, it might be helpful. And I'm hearing a March date, but maybe having activities that were targeted at that date and getting prepared to have that information. So elected officials, school districts all have weekly newsletters. Universities have all letters. I mean, you look at your large employers in the state of California and just make a list. So I would venture to say that that libraries have their cities all have newsletters. They have all commissions. This needs to be a more targeted, unified.
So I'm happy to say,
plan.
Ms. Yaroslavsky, that everything you've stated is in our current plan. So
That's
there's-
good. I must have missed it.
Yeah, we talk about school districts, we talk about legislative offices and getting to them. A lot of the legislators right now are doing Twitter, which, for the younger generation.
They're
that
also
seems to be-
doing
and they
newslet-
do- And they do newsletters, yeah.
I get them, I
So
know.
that would be the ones that we're reaching out to.
And just so you know, I've done a couple meetings lately with, they're on the break right now, but everyone I've met with, I brought this up and just said we really need their help and that we're kind of coinciding with another legislative day, and everyone seems eager to participate, so.
Yeah, but it means handing people a camera-ready opportunity to print and reprint. So it's more than the phone conversation, it's more than the meeting, it's meaning, being ready to deliver.
Agree. And in addition, I also partner up with California State Bar and legislators, and we do outreach. And we did a couple weeks ago in Yolo County with the district attorneys and along with their representatives. And so we do that as well. I agree, that's a great avenue, and we do take advantage of it.
So again,
Dr. Levine.
Again, this is an impressive list of tactics. And I think based on your comments, there probably needs to be, it would be helpful to have a process that prioritized which are the most important and most impactful, rather than, any other method of going through that list. I have a couple of questions. The word verify, I'm not sure how meaningful that word is to a lot of people. It almost sounds like a command, verify a license. And is this going to be available in Spanish, the materials?
That's what we're working on. We have an individual in our office. We can do Spanish. It will be probably difficult to do a lot more other languages, but definitely we can do it in Spanish. And just so you know where the Verify a License comes from, that's the button that's actually on our web page where you go to check the license, and that's where we've brought that from. Yeah.
Which raises the question, is that the best language to have on the button? I mean, again, it's a vocabulary issue, and whether it's a 12th grade or an 8th grade vocabulary, and whether it's eye-catching to the people who perhaps are most in need of this. And the other, and again, I mean this only in the most positive way, it doesn't tell me what to do with the information I find. So it provides no context about discipline. It doesn't even refer me to a place or a set of actions I can take to understand what I'm going to see on the website. And so we can direct a lot of people to the Verify a License button if they have questions, if they have concerns. Is there some context we can create as to what this means?
And I think our hope is that once we get because there's two things we're doing, is one is the PSA to put out there, like Ms. Yaroslavsky talked about, something ready for individuals to use that will bring individuals in. But then there's the tutorial, and that's really what we would like to have on there, because then we need to go through each item and say, what is an accusation, what is a decision, what are these, and what is available on the web page? Because I know we got some questions, well, what's available out there, and to talk about, what it lists out there, the status and the education of a physician, and then any action that's been taken, as well as where they're located. All of the physician survey information is on the profile as well.
Right, and how many Smith, John, how do you find your physician among the
multiple?
We can't find them, so I don't know how public's going to find them.
Even adding a simple, if you have questions about the information that you find, be sure to ask your physician at the next visit, or something like that. That gives me a place to go if I find the whole thing too confusing.
And refer them back to the board.
You guys know the medical board, we know the medical board.
Right.
The public's not as aware of the medical board, so you have to look at this from the framework of someone who might not be as experienced. So asking the question, whether the doctor is licensed or not, we assume the doctor might be licensed. Let's hope. But checking the license to make sure that if there's discipline against the license, you're at least making an informed decision.
Right.
So just simple English language or Spanish, Korean, whatever you want to put it in, but simple terms for people that are not as familiar with the process as we are.
And as far as the Verify license, we have kind of put this forward, after we've had the brochure and everything. We're amenable to change. We'd have to, take our brochures that we've used and use them, but we just need input as to maybe what you would think a better word than verify if you have one, or we can do a focus group or.
Oh, I would test it before discarding it,
Okay.
I guess is what I'm
Okay.
saying. I'm not saying throw it out, I'm saying, do we know that this is
It
actually
works.
going to
Okay.
accomplish it?
Okay, Dr. Kraus?
I think this is great, and I commend the outreach effort. And I like that it says verify, because if it said something easier to understand, nobody would open it. And I view this really as an introduction to the website. And I think we do need to drive people to the website, and once they get there, they'll explore it, and they'll learn more about the medical board and what better outreach is there. But I think you also understand that every member of the committee and the board is willing to help and engineer these things going forward. But I think this is a great start. Thank you.
And can I just, it's interesting, putting the two comments together. Maybe what we do is from the website, so we bring them to the website, but rather than, we can have two, check your doctor now or find out more information on the Verify. And then that's when we go into more information about what each of the items mean, what the website has, what it contains, and what you can get from that information. So maybe marrying the two issues together. I think that's actually do you see what I'm saying? Like have you can go there and you can check because some people aren't going to want to read. That's what we find, a lot of people want to go right to checking their doctor, and others want to be informed and know the most information. And we have consumer groups, in the audience right now that we can work with as to, what information would you want to see on there? What would we post? So I think that would be an option, kind of what you're going to drive. Once we get them to the website, what information do they need to see once they're there?
And just one other comment, and I don't know how to incorporate it or where, but something that communicates clearly what information there is on the website about the physician and what information isn't there. So here's what you will find when you check. And for other information, please check with your physician.
And we have that right now.
Okay.
I think it's just now putting it all together. Because we have, all the information that's public, and then we go into, complaints aren't public and misdemeanors for in this state and everything. So it's maybe putting it in one spot with it all together. Is that kind of what you're talking about,
Well,
Dr.
I was
Levine?
thinking more like, board certification or the things that are not mandatory and that are not captured fully for every doctor in the state.
And we do have that on there, the board certification, we just need to also drive them to ABMS website too, yeah.
This is a huge list of deliverables. I commend you for coming up with this extensive list. I think you're going to reach a lot of people. But do you have the staffing to carry this through? Because I look at this, and I wonder if you need to more prioritize the big ticket items, because I see Cassandra and maybe another person, and, we do have board members that can help you or participate, so call on us, but how are you going to accomplish all this?
As I told Cassandra one day, this is going to take a team effort. It's definitely not something that we're going to be able to have, just Cassandra do on her own. We're going to have Jennifer assisting in that, as well as Cassandra's staff and like I said, with a lot of the events, we're going to have individuals out in other areas that can do this because we can't travel to do that. So we'll have to use our probation unit, and then like the last thing I said was we have to have board members being willing to assist as well if we go out to events, so. And
Yes.
I think everybody's been.
I think
willing to
please
be-
call upon us to help you. I think you'll find a willing group here. Thank you. I do have comments from the audience. So if there's no other comments from board members, I'll take the public comments. Edward Barrera, you had 4 and 5, so 4 and 5, got it.
I'll be quick. First of all, thank you very much. Verify, I'm sorry, go back. Edward Barrera from Consumer Watchdog. I also noticed the Verify Your License. I don't think it's a very clear button. First of all, I think what the staff is doing, I think it's awesome. We completely support any kind of outreach, and certainly, and I've done outreach in my past, and, it's very thorough. There's two suggestions, and I think it was brought up. It needs to be in different languages. I know there's probably, obviously financial concerns, which, you would have to deal with, but I think it's incredibly important. With the explosion in Medi-Cal in the state of California, you're getting a lot of, second English language learners. You're getting a lot of people who have never, who have very rarely been able to access health care. And I think it's really important to be able to do it in, several languages. And the reality is it's also different cultural contexts. There's obviously there's a wide connection with, someone like me on Twitter, but you may not get that in, different cultures. So, please explore that. I have two other things. One is a suggestion. I think the website, the Verify Your License, it's really wonky. It's not a great, and I know it was foisted on you. And from what I understand, your previous website, your previous access was actually much better than what it is today. So I encourage you to try to push the state to make your Verify Your License much better. The search function is awful. If you put a name in, once again, John Smith, or if you misspell a name, if you do it in Google, they'll give you a suggestion. It won't happen here. And there's so many different, so many different names, so many different cultures, once again, when it comes to doctors. And then the other thing, it's a slight concern. I know that there's a push, and I know the full board will be talking about this tomorrow, about probation and notifying doctors. I hope this is not being considered to replace the idea that doctors need to notify their patients about probation. Anyway, thank you.
Thank you for your comments. The next speaker is Lisa McGiffert.
Thank you. I'm Lisa McGiffert, the Director of Consumers Union Safe Patient Project, and we commend the board for this outreach plan to educate the public, and we look forward to working with you and helping you with getting the word out. These educational efforts need to be incorporated in your daily work. This shouldn't be a one-time campaign. This should be integrated, and you should think about ways that you can integrate it in your regular work. And I agree with some of the things that some of the board members have suggested to, explain to people what information am I looking for. That's very important. I also hope that this is not seen as a substitute for the petition that we've put forth to get physicians to tell their patients that they're on probation. Those patients are the ones that most efficiently and effectively can be reached by their own doctors. I see one of your biggest hurdles is that most people don't know who the medical board is and what you do. And we've done some polling in the past relating to hospitals and found that people don't know where to file complaints with hospitals. And I'm sure the case is similar to with doctors. I agree with some of the comments about taking a different approach and using more plain language. Verify a license doesn't work for most people. Use language like look up your doctor, check out your doctor's background. That kind of information would be much more effective. And that should be on your website as well as in your materials. And this is very common in other states. They use this Verify a License, and we don't like it much. Another comment is that your website has a link to something called public documents. That links to all your orders. You could easily change that to be more clear to patients. It says something like, disciplinary actions taken by the board or something like that. And that is a very quick way to look up to see if your doctor is under some kind of order. We encourage you to set some standards, like set some kind of baselines, check your website hits, and maybe do a survey and see how many people in California know about the medical board. There are surveys that are done pretty regularly, and I bet you could get a question in them without much cost. So I would encourage you to do that so you can actually see your progress over time. I know you've talked about budget. We've got some ideas about low-budget ways that you might be able to reach people. We encourage you to use social media and Twitter and Facebook. This is where people are. Use graphics, that gets attention. And also provide direct information about doctors who have been disciplined. People need to understand why this is important to them. They might not understand that. The other thing is the sign that's in every doctor's office.
Please
it does
conclude.
not inform people what they need to know. It doesn't say you can take complaints. It doesn't say where to complain and what you do. So you can change that sign, and I would encourage you to do that. Thank you.
Thank you for your comments. I have next speaker is Ray Grulich.
Hi, I'm Ray Grulich. I'm with Consumers Union Safe Patient Project. I'm one of the members of the California Safe Patient Network. As Lisa McGifford just said, we commend the board on this Verify a license program, and some of my fellow advocates and I were across the street today, and I really want to commend you. Some of your workers came up to us, and we really liked the brochure. It was very impressive, and we appreciate your efforts. But we want to make a point that once patients get to your website, that the documentation regarding physician discipline is often difficult to read and to understand. You know, the National Institute of Health and even Medicare recommends that public reading materials be kept at a 6th grade level. And because this documentation is so difficult for some people to really digest, we recommend that the board create perhaps a brief summary in plain language for each discipline physician on your website to describe a history of the violations, a description of them, and the license restriction of these physicians, and a timeline for their probation so that people will understand what's going on when they get to your website. You could have a place on your website where these summaries are aggregated and update those summaries on a monthly basis. Also, you know, according to a Pew Research Center U.S. analysis, seniors who are the most likely to seek health care in this country are also the group most likely to say that they never go online. About 4 in 10 adults 65 and over, about 39%, don't use the internet. Only 1 in 5 African Americans and 18% of Hispanics and 5% of English-speaking Asian Americans don't use the internet. So we recommend that the board particularly target this segment of our population of healthcare patients. Maybe enlist community-based organizations and others to reach out to these most in-need patients for, you know, to give them access to this very important information as well. So then the last thing is just to, again, translate all of this very essential information into other languages. There are so many Spanish-speaking healthcare consumers and so many other languages spoken in this state. We want to reach all of the consumers in California. Thank you so much.
Thank you very much for your comments. My next speaker is Marion Hollingsworth.
Good afternoon. My name is Marion Hollingsworth, and I am a member of the Consumers Union Safe Patient Project. Last week, the medical board issued a press release encouraging all consumers to consult the board's website regarding their doctors. There were 2 numbers for consumers to call for help if they didn't have a computer. I'm here to tell you that the call-in system is unreliable. As an advocate, I thought I would try these numbers. I will say the non-800 number is easier to use. The first time I left a message for a call back, and I received a call 21 hours later. I gave the employee the name this doctor goes by in his practice. I spelled it out for her and waited while she looked it up. She quickly said she couldn't find it. When I asked her to recheck, she reiterated that the name was not on the website and hung up. A couple of days later, I tried again using the other number. Again, the employee could not find the name, so she put me on hold. After 10 minutes, a recording came on asking for the medical license number, which I didn't have, and it's not found on the website or online. I left a message but was never called back. Now, I have to admit, I did test these people. I knew this doctor uses his middle name in his practice, but that he goes by his first name on the medical board license. And that middle name is spelled differently on Breeze than he tells his patients. To find him, you have to look up his last name and scroll through several pages guessing what his name is. It's very confusing to patients, but it's very clever on the doctor's part. You see, any doctor with any slight deviation in the spelling or use of his name cannot be easily found on Breeze. This not only fools the public, but apparently also medical board employees. Now, the doctor is not the only one who uses a different name with the board than he does with his practice. I can give you names as well of others who do this. Now, it would be good for his patients to know about his history because he does have one discipline and one accusation on his record. Oh, and by the way, one time when I called, I was told that Breeze is not for public use to look up a doctor, but it's for doctors to change their records. So I don't know what happened there. I did go to Horton Plaza to check out your info table. I went there yesterday at 2:30, but you were gone, and I thought you were there from 11 to 3. I guess I got my information wrong. Today, employees are very helpful, and of course, you did find the doctor I was looking for, but the internet connection was very spotty, so the on-site locations might have to work with that. The bottom line is the call-in system is no more effective than the Breeze website itself. The only reliable way for consumers to truly be informed is for the medical board to require doctors to tell their own patients of their status themselves, whether they're in good standing or whether they're on probation. It's much cheaper and much more effective. Thank you.
Thank you for your comments. My next speaker is Yvonne Chung.
Good afternoon, Yvonne Chung with the California Medical Board. CMA does support efforts to help patients to become more informed. We also have some concerns regarding understanding terms on the website. For example, in terms of if you're going to be directing patients to the website, you're going to need a lot more explanation about what the various statuses mean, because by my count, I think there are 7 or 8 different statuses where a physician is no longer practicing, and ranging from canceled, surrendered, inactive, all of which sort of have a negative connotation, but not all of them are related to disciplines. So I think that will have to be fleshed out and taking another look at how those terms are used, and whether or not, explaining what their disciplinary action was for, if it was related to patient care. I don't know if patients are interested if their physician has failed to pay their taxes last year and has a suspension for that, but I think it should be made clear. And if this is going to be a campaign that is going to be sponsored by DCA, you might want to think about adding other professions to this as well, because as you know, physicians are not the only ones who have licenses. They have other practitioners in their practices as well, and I think a lot of patients probably don't even know if they are being seen by a nurse practitioner or an MD or a DO. It's unclear if a DO would show up. They're not regulated by you either. So, what we do is when we get calls from patients asking about their dog, we encourage them to have a dialogue with their physician if they have concerns, and you may want to include similar language. And we're looking forward to participating in your stakeholder group meeting. Thank you.
Thank you very much for your comments. Any other comments from members in the audience? Any comments from those on the telephone?
Hello, Amber. Any calls on the phone?
Yes, we do. One moment.
Okay. Go ahead.
This is Dr. Gill, Kenward Gill. I'm calling from Fresno, California. And this
You may have to turn up your volume just a little bit for us, please.
Hello, is it audible?
Good. Yes, that's fine. Thank you.
Okay, I'm calling from Fresno, California, and this pertains to some of the speakers have already mentioned is some of the doctors don't use full legal name, and that poses challenges even in terms of communicating between the physicians. So I would encourage the board to notify the physician the need to use the full legal name and avoid confusion that exists. And the second thing I wanted to talk about the BREEZE system, that DOs are also licensed, and the BREEZE system sometimes does not cross-populate even the fictitious names and the names of the people, some of the doctors. So BREEZE is not a fully effective way of searching for names or fictitious names. And I've done some research and spoken to people who handle the fictitious name permit in the medical board, and they've also expressed the same thing, that the osteopathic board does not really report the same information as medical board does. So I feel the system is not foolproof. Even the DocInfo website that was recently launched it is full of errors. In fact, a physician that has been shown as active practitioner has his practice actually stopped by the board. There was a cease to practice order sent over by the board, and he's still shown active. So those are the things, the various areas, various avenues where you verify physician information, and none of those seem to be universally accessible, or none of those shows the information to be accurate. So if something can be done about that, I'll greatly appreciate it. Thank you.
Thank you for your comments. Do we have anybody else on the telephone wishing to make a comment?
Yes, we do.
Okay, go ahead.
Hi, this is Susan Chinese. Can you hear me?
You might have to turn up just a little bit, or the audio just has to be turned up a slight bit. Try again.
Okay. Can you hear me now?
Oh, that's perfect, thank you.
Okay, great, thank you. I just have a question for you, Leslie, that I'd like you to think about. When I look it up, quite a few good sources say that California has over 200 different languages spoken here. People with over 200 different languages, including the refugees that we welcome. So I'm wondering, when a person calls in to ask about their doctor, instead of looking them online, and they get a recording, and there's no translation service, how is this going to help all of these different nationalities and languages? That's just my question. Thank you.
Okay, well, thank you for your comments. Staff has recorded your comments. Okay, thank you very much. Anybody else on the telephone that I've missed?
None at this time.
Okay, have I omitted anybody in the audience? And now I go back to my fellow board members for any other additional comments. Dr. Levine.
So you have to look pretty hard on this to find the website. I think I'm not saying discard these, but next version, you need the website address prominently on the front. It's on, to be honest, it's on the back, hidden in small print below the mission of the medical board. And I looked a couple times to be sure I wasn't missing it, but
It's on the front. Oh.
Any other comments from members of the committee? Yeah, also, this is a very busy brochure. So I'm, with my bifocals, I'm trying to look at it, but it might be a little busy, but, and one question, if a patient's doctor is a DO, does the website say to them, well, if you can't find it, make sure the doctor's not a osteopath?
We do. We have that on the page where you first hit when you go in to read that information, that
Oh, that's
they
good.
could be listed as an osteopathic physician too. But
there
if
are
they
many-
don't
yeah.
read that, then they won't know. If the one thing is, if they go in on from the BREEZE webpage straight into BREEZE rather than
Right.
through our webpage, when they look up the last name, if they just do it by last name, it'll pull up the physician, whether they're a MD or a DO. So.
Okay, because a lot of patients sometimes don't
Yeah,
know
they
the
get confused
distinction, and they keep saying, oh, I can't find it, and they're with the DO board, so it's different.
Right.
Thank you.
So one thing I don't think I saw on the list of so many things that you were going to contact is that there, in California, there's so many organizations that support ethnic minorities, community health groups. They're nonprofits. They're there to help bridge roads between the community and the providers, in not only for doctors, but other health providers or other rent control or for housing uses. And I would suggest that you engage some of them as your community stakeholders, because then they can also help with translation and also to disseminate the information. That I think that they can be really very good partners with what you're trying to get done.
Thank you. Any other comments from members of the committee? Seeing none, do I have a motion regarding this plan? You need a motion?
I don't know. Yeah. I think you.
What do you want? What do you think, Carrie?
Can I make a request to staff? How would that be?
Sounds like a good idea.
Would you like it?
First, to commend all of you, the three of you and the folks who support you, for what is a very ambitious effort to truly cover the waterfront. And I think it would be helpful for the committee at our next board meeting, at the next committee meeting, to see perhaps a refined set of next steps and for my purposes, a prioritization of high impact, likely high impact, high volume points of contact, so that you know we can be comfortable that you are stewarding your own resources in ways that are going to have the impact that you want and that represent the quality of the work you're doing.
And I think the comments don't really detract from your work. I mean, they're all constructive, so I think we all appreciate the amount of effort. I mean, it's stellar work. So we just give suggestions, so please don't take it as criticism. But for the future, like Dr. Levine says, if you can prioritize your plan, your deliverables, because there is an impact on staff, so we have to be cognizant of that. So, thank you very much. Anybody else?
I'll move to adjourn.
We're not
Wait, no, we have the next and last, I know, the last agenda item is future agenda items. Do I have any comments from board members regarding future agenda items? None. Do I have any comments from the public regarding future agenda items? I do not have any speaker slip. I don't want to leave anybody out. Dr. Hawkins.
Just follow up on the demographic study.
Would
that be in this our committee?
It's for the enforcement committee.
It's the enforcement committee. Right, I know we get
Which has now 20.
confused, it's changing names. Any comments on future agenda items on the telephone?
Any callers on the phone, Amber? Amber, can you
We do
hear me?
have one at this time.
We have one comment? Is that what you said?
Well,
Go ahead.
This is Dr. Canver Gill. I'm calling from Fresno, California. I wanted board to consider putting foundational models of practice in medicine in state of California, especially after the 2009 Affordable Care Act. We've seen a lot of bundled payments coming in and hospitals gaining a lot of control on the way the physician practice medicine. I'm not sure if the enforcement meeting has already happened. I wanted to bring a case, a couple of cases for the enforcement to look at the pattern that's going on. So it would be a good idea to have a discussion on the foundation, non-profit foundation, 1206L, and the way they practice medicine in the state of California and the role of hospitals and the line that is being crossed so many times in regards to those. So if you could have that and corporate practice of medicine somehow talked about all over again, I'll really appreciate it. Thank you.
Thank you for your comment. Any additional comments from anybody on the telephone?
We will take our next one.
We have an additional comment. Okay, go ahead, please. You may speak now. Can you hear us?
Carol, your line is open.
Yes, we can hear you. Go ahead. Go ahead, we can hear you. Go ahead. Oh, we just heard the
There
operator.
is no response from this person.
No response? Okay. Anybody else on the telephone?
No persons at this time.
Okay, thank you very much. Now do I have a motion to adjourn? Oh, you don't need a motion. Meeting is over. Thank you. Thank you very much for your attention. Patience.
And I want to welcome you to the Enforcement Committee session of the Medical Board of California. I'm Dr. Felix Yip, Chair of the committee. I would like to ask all of us to please turn our cell phones to silent, and for board members, please make sure they are off the table so we can avoid feedback noise. Since we have the time constraint, I may speak a little too fast, but stop me if you need to. You may notice board members accessing the laptop during the meeting. They are using laptops solely to access the board meeting materials that are in the electronic format. This is an official business meeting of the Medical Board of California. As such, disruption of the board's business will not be tolerated. We have a designated time on the agenda for public comment, and we'll be asking for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I would ask the person to conduct himself or herself in such a manner that permits the board to transact this business. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand and you'll be recognized. I would like to request all speakers to complete a presenter slip so I can call your name by the appropriate time, and the record of this meeting can be full and complete. However, it is voluntary. Please give the speaker list to Ms. Tu on that side of the table. This meeting will be available via telephone conference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will facilitate the telephone conferencing process. For those members of the public participating via telephone conference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, please press star 1. You will hear a tone indicating you are in the queue for comment. If you change your mind and do not want to make a comment, press the pound sign. Please remember to mute the volume on your screen to avoid feedback. Assistance available through the teleconferencing meeting. To request assist, please press star 0. Each person will be limited to 3 minutes per agenda item. However, during agenda item 2, public comments on items not on the agenda, the board has limited the public comment period for individuals on the telephone conference and those present here today to 20 minutes. Therefore, after 20 minutes, no further comment will be accepted. During public comment on any other agenda item, 10 minutes will be allowed to comment from individuals on the teleconference line and those in the audience. After 10 minutes, no further comment will be accepted. Dennis Frankenstein will be assisting with receiving the public comments via the telephone conferencing during this meeting. And I want to remind all speakers to please stay on topic and keep your comment to 3 minutes or less. We plan to end the meeting today at 4 p.m., which is 30 minutes away. We may take some items of order to accommodate the schedule. And that's the end of business, by the way, too. So I would like to call the meeting to order and ask Ms. Chu to please take the roll, call the roll.
Dr. Bolat?
Present.
Dr. Kraus?
Here.
Ms. Yaroslavsky?
Present.
And Dr. Yip?
Present.
Sorry.
Okay. Quorum's present. I would like to remind the members that we'll be taking a roll call also on all the action items. Moving to agenda item number 2, public comments on items not on the agenda. And I don't have any speaker slip on number 2. Do we have any requests on the telephone line? If no-
Amber, do we have any calls on the line?
Yes, we do have someone in the queue now. We'll go to them.
Thank you.
Hello, this is Dr. Gill again. I just was briefly discussing the matter with you in the other part of the meeting, but I just wanted to focus and request you to talk about in future meetings on 1206L foundation models, which are essentially being operated by non-profit hospitals as separate product line or division of a hospital entity, which is something that legislature didn't intend. But some of the hospitals have gone into this forbidden domain, and some of them have even gone to the restricted territory, saying that even the clinics that otherwise meet the requirements of 1206D could be termed as a foundation. Well, the California legislature intended to create a very limited exemption from the clinic licensure laws for the physicians who practice medicine through a non-profit entity in order to raise funds for medical education and research. The legislature did not intend to provide esoteric pathway for tax-exempt hospitals to attempt to organize and control a large group of physicians in the outpatient setting, and in doing so circumventing the corporate practice of medicine prohibition. I looked at a few patients that were recently abandoned by a large hospital group and some of the affiliated physicians, as one of the competing IPA was about to get the contract for the care for these managed care patients. This is essentially, and this is actually the thing that which worries us most, because this is what you're going to be seeing more and more so with the bundle payment systems that are coming up as a future of the medicines in 2018 onwards. I would want the board to pay some attention to how hospital executives and administrators are trying to push the non-medical agendas to drive medical policies and practices by creating ill relation between the professional ambitions and absence of moral innovation, and linking the economic imperatives to the professional self-interest. So I would want board to comment on 1206L Foundation in future and the role they have in providing care. Many of the foundations that you see in California are structured that way in various models. They're organized very differently, all of them, but they basically, the end goal they're trying to achieve is the same. So please, if you could get some time and put this on agenda sometime soon. Thank you.
Sure, thanks for the comment, appreciate that. Anyone on the telephone queue? Any other public comment? Speaker? No?
Amber, any other calls on the line?
No other comments at this time.
Thank you.
Okay, great. We'll move to item number 3, approve of minutes from January 29, 2015 meeting.
So moved.
Second.
That's quick. Are there any public comment from those in the audience? From the telephone? Okay, Ms. Tu, please call the roll.
Dr. Bolat?
Present.
Dr. Kraus?
Aye.
Ms. Yaroslavsky? Aye. And Dr. Yip?
Aye, minutes approved. Now we move on item number 4. Ms. Webber, she already presented herself, will provide presentation on utilization review.
Thank you, members. As you may recall, the board asked staff to place this topic on the agenda following public comment from former board member Dr. Lowe concerning a UR utilization review interaction that he had had involving one of his cardiac patients. Among other concerning details, the reviewer was not a cardiologist, but deemed a procedure requested by Dr. Lowe to be not medically necessary. And the reviewer did not identify him or herself. So I looked into this and trying to understand how this could possibly be. So I do have some information to present to the members. So the goals of this presentation is we're going to review and discuss a brief overview of utilization review. I will sometimes say UR. And we're going to be discussing UR in workers' compensation context as well as the managed healthcare context. We're going to talk about the board's historical position on UR, the complaint and investigation process relating to UR, which I believe I will be able to streamline and go quickly through, the statutes and regulations impeding investigations relating to UR complaints, and then some suggestions for changes in the law and in outreach. So first, in the workers' comp system, it's used to look at past and current treatment and provider requests for future treatment to determine if the treatment was or is medically necessary. And in workers' comp, the term medically necessary is defined as follows. And in workers' comp, the standard of care is set forth in writing. And it must be based on these standards in the order that they appear. And so first, if it's dealt with by the guidelines adopted by the administrative director pursuant to the section, that has to be followed first. And then there's some other things, if it doesn't fit into the first one, it may fall into peer-reviewed scientific literature, nationally recognized professional standards, expert opinion, generally accepted standards of medical practice, and then finally, treatments that are likely to provide a benefit to a patient for conditions for which the other treatments are not working. And all of this, of course, is required by code sections or regulations. In the managed healthcare system, insurance companies are required to define and disclose their utilization review process, and the criteria used by the plan to authorize or modify or deny healthcare services has to meet certain criteria, including be developed from actively practicing healthcare providers and be consistent with sound clinical principles and processes. So it's sounding like in the law there is this recognition that utilization review involves the practice of medicine, okay? And so now we're going to the board's historical position on UR, and the board in 1998 adopted a resolution declaring that the making of a decision regarding the medical necessity or appropriateness for an individual patient of any treatment or other medical service constitutes the practice of medicine. This was reaffirmed in 2013 at a quarterly board meeting. And this position is consistent with our Business and Professions Code Sections 2038, which defines diagnose or diagnosis, and 2052, which deals with practice without a certificate. And the board is not alone in holding this position that UR is the practice of medicine. For example, the Arizona board took action against a medical director for Blue Cross after a treating physician complained that that director refused to pre-approve a patient's laparoscopic cholecystectomy, finding it was not medically necessary. And the Arizona board's disciplinary action was supported by the Court of Appeal, which found that when a utilization reviewer substitutes his or her medical judgment for the treating physicians to determine that a surgery is not medically necessary, it is a medical decision. This position is also consistent with the American Medical Association's policy regarding the ethical obligations of medical directors. It's also supported by the CMA, and I would like to thank Yvonne Chung and Michelle Rubalcava for meeting with me and putting me in touch with some experts to help me understand some of the issues regarding UR better. So thank you for that. We get complaints from patients whose treatments were delayed or modified or denied, from treating physicians whose recommended treatments were delayed, modified, or denied, and also from representatives of managed care plans whose denials have been overturned by UR reviewers, saying that it was without sound basis. The review of complaints, it follows similarly our review of quality of care cases. I am going to move quickly through this part. It goes through the central complaint unit. The patient medical records are obtained from the treating providers, along with any correspondence from the UR reviewer that is accessible. And the UR physician, if known, is provided a summary of the complaint, and a request is made for all the records in his or her possession, and they can write a statement or explanation. And the case is reviewed by a medical consultant. Then if the consultant determines that more investigation is warranted, it's sent to the field. So the board's jurisdiction in UR cases, we need to distinguish between a utilization reviewer's decision regarding medical necessity or treatment from the insurance provider's determination regarding benefits based on that decision. The board's jurisdiction is over the known California licensed physician determining medical necessity, but not over whether the benefits will be paid. So our impediments to the board's role as this oversight and public protection agency is that an expert reviewer does not have to be licensed in California in the workers' comp system. They have to be licensed, but not limited to California. And then once a workers' comp matter is elevated to the independent medical review level, the name of the expert reviewer is required to be kept confidential. And ironically, if a worker does have the ability to appeal a decision, but based on very limited circumstances, such as the final determination was procured by fraud, the medical reviewer was subject to a material conflict of interest, or the final determination was the result of bias, all things that could be very difficult if you don't know who this person is. Under health plans, again, the physician providing the independent medical review does not have to be licensed in California, although California licensed physicians are supposed to be given preference. I'm not sure how that's verified. And again, the independent medical review organization shall keep the name of the reviewing physician confidential, except under very limited circumstances. But this is something that's very important for medical directors to know, and that is that the medical director in the workers' comp system is required to be licensed in California, and same is true under health plans, so I will move quickly through these slides. But it's important to point out some of the phrases that I don't know is obvious to medical directors in this position, that they shall ensure that the process by which the employer or other entity reviews and approves, modifies, delays, or denies requests complies with the requirements of this section. And then it says, nothing in this section shall be construed as restricting the existing authority of the Medical Board of California. And then, again, in regulations, the medical director is responsible for all decisions made in the utilization review process. Similarly, in health plans, medical director has to hold an unrestricted license. They're responsible for ensuring that decisions comply with the law, and part of that law says, it shall be consistent with clinical principles and processes. Again, a medical decision-making flavor there. So I do have some suggestions for change, because I think that there needs to be some reconciliation in the law. These are not, the labor code and the health and safety code are, the board doesn't have a whole lot of influence over that. But there needs to be some reconciliation, and I would like to see the board support legislative changes to require that the physician be licensed in California, have a similar board certification as the treating physician who they are opining about their recommendations, and identify themselves in their reports. We all have to take responsibility for what we say and do, and the impact that it has on people. And then finally, supporting outreach efforts to educate medical directors about the board's oversight in the utilization review process, because I have it on good authority that that message may not be out there very well, and they are responsible for a lot of decisions flowing through. So with that, I'll take questions.
Dr. Kraus?
Thank you, Ms. Webb. This is very illuminating. It's an apparent contradiction that utilization review is defined as the practice of medicine, and yet utilization reviewers can effectively practice medicine in California without a California license. So I agree with your suggestions for legislation. I'm interested to know if you have statistics on how many complaints over the last few years the medical board has received regarding utilization review, and what those findings have been, and how many of those complaints could not be adequately investigated because of reviewers who were not licensed in California.
I know that Ms. Ramona Carrasco did a presentation, I believe last October, and she had some numbers. I unfortunately don't remember them. It's a very small number of complaints. As far as I know, it has not progressed through disciplinary action, and there are a number of them that cannot move forward because we don't know who the reviewing physician is, or they're out of California.
Thank you.
I want to thank you for this detailed report. I've made comments on several of your slides and would like an opportunity at a later date to just ask you questions without taking up the time here, but to absolutely volunteer or try and figure out a way that we can do better outreach to those entities that need to know about this. I mean, this is really important, as well as doctors need to know. I just think this is, hopefully it takes the place of a newsletter article. Excellent. Thank you.
We have two requests to speak from the public. Ms. Genevieve.
Good afternoon, Genevieve Clavrol. I'm totally appalled of the wormwood camp system. Most of the doctors, I would say 99% of the doctors who review any kind of chart are all emergency physicians. They are the less likely to be competent to care of long care treatment. Because all they do is today is a trauma. That's all they are. That's not they are bad doctors, but they are not. About complaint, 4 out of 5 reviews are denied by the reviewing system. So either all the doctors who take care of workman's comp are incompetent, or the system is really rigged. And I think that the system will really need to be looked in detail. I think it's scandalous. And like I said, either all the physicians who take care of workman's comp are incompetent, or is something wrong in the system. The physician who does the review is through Maximus, who has a sole vendor contract in the first place, which is totally inappropriate. And I think some inquiry really needs to be done to see how this system is being dealt with. And I have really followed that very closely, and I think that something needs to be done, and I'm glad to see you looking at it, because that's, like I said, ER physicians are fantastic for the ER now. They are totally incompetent for long-term treatment. And every review I have seen, and I have seen a lot because I've been looking at it carefully, including the one over my case, are all ER physicians.
Thank you. We have Ms. Yuan Chong from CMA.
Yvonne Chung with the California Medical Association. We really appreciate the board's attention to what we feel is an underenforced area in the practice of medicine. And we agree with Ms. Webb's recommendations that more transparency is needed with regard to the physicians who are actually conducting the reviews, and that medical directors should be made aware that the medical board can't take action against them. A suggestion for a model for how you might be able to get more information about the physicians that are performing utilization review. The Department of Consumer Affairs has a registration system for telephone medical advice services. So if you're Kaiser or any sort of health plan, you have an advice line, you have to register, and the plan has to provide a list of all the providers who will be providing that service, whether they are in state or out of state, and whether they are licensed. So that might be a way, sort of kind of along the lines of what you do for fictitious name permits, to really get at the entities that are providing the service, because I think that's really the issue here. It's not necessarily the individual physician. And this would also help you determine, in terms of the reviewers, whether or not appropriate supervision is being provided, because in many of these cases, the initial review is actually not done by a physician. It may be done by a nurse practitioner or some other health professional, and that will help you to figure out what the chain of review actually has been and help in your investigations. Thank you.
Thanks, I appreciate it. Any comments from the telephone?
We do have somebody in the queue. We'll go to them now.
Thank you, Ms. Webb, for such a wonderful presentation. My name is Kanwar Gill. I'm calling from Fresno, California. I sent you an email in regards to this metro last night, but I want to tell you that unless the UR people are asked to get a California license, there is really nothing much I see happening on this arena. I'll give you an example. I had a patient, a state worker, state of California employee, where a UR was done apparently by a Texas physician. And that physician, we found out later on, was not even part of a UR. It was done as part of an internal audit for a company owned by a bigger insurance company. And subsequently, I had to contest with the medical director, a California licensed physician, to get a surgery for my patient. And the issue they were bringing up was causation and compensability of the claim, which has nothing to do with the medical necessity. So anyway, long story short, the way we resolved the issue was I asked the patient to file a complaint against me personally so that I can explain it to the board. The complaint was never filed, the surgery was done, patient was happy. But what I'm trying to say is there is a layer of UR being done by unlicensed people. There is a layer of UR being done by individuals who are not part of UROs. And that those kind of a complaint falls under the purview of medical board when that kind of an action results in an interfering of the medicine practice of a California physician. So if a reviewer from outside, working outside of the URO, makes a determination that impedes the practice of medicine in California, board is entitled to take an action, and I would want to see in those cases board to take action. I sent you an email. It has a detailed explanation of what was going on for 2.5 years, a part of a state fund program involving three major workers' comp group, Kaiser, US HealthWorks, and Concentra. And the scheme of things was basically denying and impeding the decision stream and reach the desk of a UR reviewer. And a lot of time, patients were being affected. In fact, there was a significant cost saving that was told to me occurred as part of this illegal UR thing that was going on. Out-of-state physicians were doing it. And no action seems to have taken to date against the medical director. So I would want you to make a legislation effort towards getting every UR reviewer to have a California license. At least you guys can go ahead and take some action against those people if they do things which are inconsistent with the Medical Practice Act. Thank you.
Okay, thanks, appreciate it. Dr. Kraus?
I'd like to move that the Enforcement Committee recommend to the full board, in accordance with Ms. Webb's presentation, that we support legislative changes to require utilization review and independent medical review physicians be licensed in California, be actively practicing, have similar board certification and/or training as the treating physician, and identify themselves in their reports, just as Ms. Webb suggested.
Let's second that.
And I do want to make it clear that this isn't legislation that we would sponsor, but there are efforts periodically to do this, and so the board would take a support position on bills like that.
Yeah, I think it's important our staff have conversation with the Department of Managed Care or the California HMO Association, looking at the qualification of the medical directors, so that we can have a better idea. So we have a motion second on the floor. Ms. Tu, call roll, please.
Dr. Bolat? Aye. Dr. Kraus?
Aye.
Ms. Yaroslavsky? Aye. And Dr. Yip?
Aye. Recommendation approved. So move to item number 5, Ms. Robinson. We provide an update on the demographic study.
Good afternoon, Chair and members. You may recall that I presented information to this committee on ethnic background data for complaints, investigations, and discipline at the October 23rd meeting. I also presented data from fiscal year 10-11, 11-12, and 12-13. The data, I also gave data from fiscal year 12-13 with regard to the type of discipline that was imposed. At this meeting, you directed staff to research potential third-party organizations that could analyze the data and complete a more in-depth review. In January, board staff met with the California Research Bureau, as I will now refer to as the CRB, and followed up with a meeting with interested parties to discuss the disciplinary action demographics. At the January 29th meeting, this committee approved the board to enter into a Memorandum of Understanding, or MOU, with the CRB. In July, board staff met with the CRB to solicit input on the MOU, which was executed on July 29th. In early August, board staff met with the CRB to discuss the data needed to conduct the study. Board staff provided the data to CRB on August 26th and 27th. That included disciplinary action records from fiscal year 2003, 2004 through 2012, 2013. On October 1st, I checked in with the CRB to see how the study was progressing and to get an estimated timeline for completion of the study. The Bureau informed me that they were in the process of conducting a thorough review of the data we had provided them. And once completed, the CRB will develop a research plan, outline a work schedule, and then begin conducting interviews with outside stakeholders. This Monday, the CRB requested additional information on the physician survey data that our IT staff is working on providing to them. So the study is moving forward. I will continue to monitor the CRB's progress and look forward to giving further updates. This concludes my update on the demographics study. Are there any questions?
Any question from the member, Dr. Kraus?
Thank you for following up on this.
You're welcome.
I also recall at one of those meetings that my input was offered, and yet I've not had contact from them. So if you could remind them, particularly at this stage where they're designing their study, to be in touch with me, I'd like to work with them.
Most definitely. As soon as they review the data, they're going to reach out to the outside stakeholders, which includes you.
Thank you.
And Dr.
Absolutely.
Kraus, that is specifically in the MOU.
Yeah.
Thank you.
Can I suggest that we have another update at our next committee meeting, please?
Oh, absolutely.
Thank you. Excellent. Thank you
Thank
for
you.
following through and following up on this. Thank you.
No problem.
I don't have requests to speak from the audience. Anyone from the telephone?
No one on the phones at this time.
Okay, great. We'll move to item number 6. Our new chief, Ms. Depp. Enforcement program update.
Thank you, Dr. Yip and committee members. To provide a quick staffing update, Enforcement Program Management continues to fill vacant positions within the various units of the Enforcement Division. In the July 2015 Enforcement Summary, it was reported that the Central Complaint Unit had 5 vacancies. 4 of those vacancies have been filled and the new employees have begun working. Regarding the 5th vacant position, the top candidate is progressing through the hiring process, and we expect the candidate to begin employment shortly. The Central Investigation Office filled its remaining Special Investigator non-sworn position, and the new employee is scheduled to report to work on November 2nd. In the Probation Unit, the Northern California Inspector 1 position was filled, and the employee reported to work in September. Interviews have been completed to fill 1 Inspector 1 position in the LA metro area and 1 Associate Governmental Program Analyst in Northern California. The Discipline Coordination Unit is fully staffed. Presently, in the Central Complaint Unit, the number of days it takes to initiate a complaint has increased to an average of 15 days. However, staff continues to work together to reduce this time frame to 10 days to ensure compliance with Business and Professions Code Section 129. Additionally, analysts are continuing their efforts to reduce the number of days needed to complete the processing of complaints. This has been a difficult goal to achieve due to the vacancies in the Central Complaint Unit, but the recently hired staff are making significant strides in learning their new functions. Management is confident they will contribute greatly once they have completed their training. Furthermore, the management team in the Central Complaint Unit has recently started conducting case reviews with staff as a way to monitor the workload and provide a forum to assist the analysts with moving through the complaint handling activity by providing timely direction in processing complex complaints. Lastly, effective August 31st, 2015, the board received authority to once again issue citations containing orders of abatement and fines to licensed physicians for violating the statutes mentioned in California Code of Regulations, Section 1364.11. The special investigators in CIO are each currently carrying a caseload of approximately 35 to 40 cases. However, this will decrease with the addition of the new staff person that will start working in November. Since the last summary report of July 2015, the unit has closed 58 cases and has transmitted 6 cases to the Attorney General's office. 3 were for convictions, and 2 were petitions for reinstatement, and 1 was a medical malpractice case. Staff in the Discipline Coordination Unit continues to focus their efforts on restoring public disciplinary documents to the board's website to ensure compliance with Assembly Bill 1886. Staff has been offered overtime to finish the project, and management has devised a daily schedule for all staff to work on this project with the hopes of completing it by December 31st, 2015. Board staff will also be looking to hire temporary help to finalize this project. In the probation units, inspectors in each office are beginning to see orders that include the new disciplinary guideline language contained in the recently implemented uniform standards for substance abusing licensees, which took effect July 1 of 2015. On November 4, 2015, the inspectors, supervisors, and management will meet to discuss and develop a comprehensive training plan for the unit's inspectors, focusing on subjects that will enhance their skills in monitoring probationers. In addition, I've been looking at reviewing the probation operations manual, conducting case reviews, and taking a look at current policies and procedures to ensure where improvements can be made in this enforcement program. An issue has been raised by the Office of the Attorney General regarding use of the same investigator that works a complaint both criminally and administratively. The Attorney General's office is asking for the Division of Investigation to develop a parallel policy for these types of investigations. During the month of November, the medical board will reach out to HQIU and the Attorney General's office to address this concern of conducting parallel investigations with the goal of reaching an agreement that works best for all agencies. In addition, a process needs to be established with HQIU where the board is able to monitor the complaints deemed to be criminal investigations. This oversight will ensure these complaints are being processed in a timely manner to include the filing of an interim suspension order or an accusation if the criminal investigation is not advancing. I have begun to have these discussions with their new deputy chief. Regarding vertical enforcement legislative report, on October 7, 2015, staff and I met with Deputy Director Michael Gomez, Senior Supervising Deputy Attorney General Gloria Castro, and Supervising Attorney General Terry Jones, and retired DCA Attorney Anita Scurry to discuss the highlights and challenges of the vertical enforcement process. Ms. Scurry will be assisting the medical board staff in writing the mandated report that is due to the legislature in March of 2016. The report will communicate the effectiveness of the process and areas needing improvement to enhance the usefulness of vertical enforcement in investigating medical board complaints. The intent is to have 2 board members work with staff once the report is drafted to review and provide feedback regarding the content. A draft report is expected to be completed at the beginning of January 2016. We hope to be able to provide a draft to the board members at the January board meeting for approval. However, it is dependent upon the ability to run the necessary reports to be able to complete the draft. If necessary, we may need to hold a special meeting for the review of the report in February. The development of a cloud to share case information electronically via a secured system has also been developed and would be utilized by staff within the Enforcement's Disciplinary Coordination Unit, CIO, probation units, HQIU, and the Attorney General's office. This system will permit the timely receipt of case information and reduces operating costs for the 3 agencies. A meeting is scheduled on November 3rd with the Attorney General's office and HQIU to discuss the implementation of this process. That ends my enforcement update. Are there any questions?
Can I just ask you a question about, you mentioned that currently investigators have 35 to 40 cases each. How does that compare to last year at the same time?
I know that they just started in July of 2014, and I'm not sure.
Approximately, I mean, is it up, is it down,
It is up because we lost, this is our non-special investigators, so these are the ones that are still with the medical board.
Right.
So they probably had, I'm gonna look, probably about 20, about 25. Okay, so they had about 5, but they have about 5 more dispersed amongst them, taking care of the one workload of the one analyst or the one investigator that's gone. So it's up by about 5.
It's not that bad yet.
No. In fact, it's going to go down because as soon as that
but it's
one
not
gets
down yet.
Yep.
Okay.
Yeah.
Thank you.
Any question from members? No? Great. We have one request from the audience for giving a presence around Ms. Marian Hornsworth. The next one? Okay. Okay. You mean for the full board? Oh, okay. Anyone from the telephone?
Amber, any calls on the line?
No questions on the phone at this time.
Okay, great. Now, we'll move on to item 7. Our director, Ms. Kurt Meyer, and Ms. Delp, on the meeting with the Office of Administrative Hearings.
Good afternoon. On October 16th, Ms. Delp and I met with Zachary Marazzini, the new director of the Office of Administrative Hearings, and Deputy Director Melissa Crowell, and Presiding Administrative Law Judge Alan Alvord. The meeting was a meet and greet as well as an opportunity to update them on the happenings of the board. We spent a significant amount of time talking about the board's new regulations pertaining to the uniform standards for substance abuse licensees. We discussed how the language in each condition should not be amended pursuant to the regulations. We also discussed the length of time for setting hearings. Lastly, we talked about the required training for the administrative law judges. And as most of you know, this is actually one of our items that's in our strategic plan. And with the absence of an enforcement chief, we haven't really been able to do that. And so I'm happy to report we actually have a very robust training that we're set up now with OAH, and I'm going to have Ms. Delp talk about that.
So beginning next month, I'll be working with Judge Alvord from OAH to schedule training with the administrative law judges. Due to the limited availability of the judges' schedules, training will be held on the last Friday of a month or during a lunchtime period. Some of the training topics will be, but are not limited to, training on impairment and how it impacts the practice of medicine, medical record-keeping standards and expectations, emergency room procedures, prescribing practices and expectations, review of systems of the body, treating comorbid patients, medical terminology and medical error, fitness for duty evaluation for physicians alleged to have mental illness, physical disabilities, and or substance abuse laws. The Office of Administrative Hearing is very receptive to receiving the training, and we look forward to the opportunity to provide this continuing training on an ongoing basis.
And I just want to add that in a lot of times when we try to set up this training, we have problems sometimes finding individuals that can provide this training to OAH, so we may be reaching out to you members to try to identify a speaker that can come in. I know in the past we used to reach out to UCD to come in, and we've reached out to PACE, but I think it'd be good if you all have individuals that we could reach out to provide that training. That would be helpful as well, some of your colleagues.
Are those training going to be in different sites like Sacramento, San Francisco?
The great thing about OAH is they can teleconference, a video conference throughout their state. So that's how they've put all of them on. In fact, they've had training in San Diego that's gone statewide, as well as in Sacramento that's gone statewide, and that's how they do their trainings.
The topics that you've given us, which are excellent, are they also included from conversations that we've had in the panel meetings as to where the weaknesses are?
Yeah, I think we've taken a lot of that into consideration. We've taken it from three things we've heard from board members and panels. We've also taken it from the Attorney General's office when we've been meeting with them, as well as then OAH themselves came up with a lot of the areas where they feel that it would be helpful for them.
Thank you.
Any question from members? I don't see a request from public. Any question from telephone audience?
There are no questions in the queue at this time from the phones.
No? Okay. We'll move to item number 8. We step again on the expert review training.
Staff is reviewing and updating the expert reviewer guidelines in preparation of the upcoming expert reviewing training class. We're aiming to conduct the training in March of 2016 in Southern California. I've reached out to the previous presenters to determine their interest in being a presenter again, and I'm in the process of securing a location for the training and continuing education credits for taking the class. In addition to setting up the training, a recruitment plan to expand the number of experts with specific specialty fields of medicine has been developed. The plan includes inserting an article in the board's newsletter that stresses the purpose and importance of utilizing experts, a revision of the board's recruitment letter to encourage participation into the program, creating a brochure to accompany the recruitment letter that will highlight the benefits, expectations, and compensation for services regarding the program. In addition, we're looking into the possibility of taking some testimonial videos of existing experts that can be added to the board's expert reviewer webpage, so prospective experts can hear firsthand about those currently that participate in the program. As well, we will be reaching out to physician groups and physician organizations to do a presentation on the expert reviewer program. The specific fields of medicine where our recruitment efforts will focus are stated in the Utilization Quarterly Expert Report, which is included in your board packet found under agenda item number 8 of the full board meeting. Lastly, regarding the expert reviewer program, the expert reviewer database called MEDEX is expected to get a new overhaul. Program staff will be recording elements needed to enhance the antiquated database and will be working with staff from the Information Systems Branch to make the system user-friendly for staff, investigators, and medical consultants to search for qualified experts to assist with complaint investigations. That concludes my update. Are there any questions?
Question from members? I don't see a slip on public. Any question from the telephone audience?
No questions from the phones.
Okay, great. We move on to item number 9.
Okay.
For the psychotropic medication being prescribed to children in foster care.
The board will be meeting with another pediatric psychiatrist to determine if interested in reviewing the data the board received from the Departments of Healthcare Services and Social Services. It has been challenging to find an expert who is able to opine regarding the data that has been provided, as the data appears to lack substance to make a determination as to whether there is inappropriate prescribing of psychotropic medications to children in foster care. The board will meet with the potential consultant on November 9th. The physician currently works for the UC Davis healthcare system and specializes in child and adolescent psychiatry, forensic psychiatry, and psychiatry. The board is hopeful that this physician will be interested in working with the board as a medical consultant to opine regarding the pending issue. On October 12th, Executive Director Kirchmeier, Chief of Legislation Jennifer Smoes, and I met with executives from the Departments of Healthcare and Social Services to give them an update regarding the board's analysis of the data they provided per the data use agreement. The board explained that the data may not be sufficient to make a decision as to appropriate prescribing and that the board is still seeking a physician. In addition, we explained that we may need to obtain additional information, and our plan is that the medical consultant will identify what additional information is needed in order to make a determination. However, on a positive note, the agencies and the board developed a notification process whereby individuals in the healthcare delivery system for foster care children can directly contact me or Enforcement Program Manager Paulette Romero if they believe a physician is inappropriately prescribing medication to children in foster care. In turn, Ms. Romero, I will contact the Department of Social Services to obtain all de-identified patient information for the foster child for that prescriber. The de-identified patient information will be sent to the board's medical consultant, who will opine on what patients the board will need to obtain patient records, if any. Board staff will then work with Department of Social Services to obtain the patient records through a court order so the board can proceed with an investigation. That concludes this update. Are there any questions?
Comments from the board? Any from the audience? From telephones, audience?
Any calls on the phone, Amber?
No questions on the phone?
Thanks, Ms. Deb, for your report and effort. You pick up so fast in a short period. I'm sure with help from our director. So, for future agenda items, any members have any suggestion, comment for the next enforcement committee meetings? Any public comment from the audience? From the telephone?
None at this time.
So we'll move on to adjourn the meeting and stay for the full board meeting.
Which is where?
Which is here, right?
So moved.
So Mr.
Moved, I've done, absolutely.
All right, great. Thank you.
Good evening. Hopefully I don't have to say good night.
It's morning somewhere, it's morning somewhere. China, it's morning.
I'm Dave Ganadev. I'm the Vice President of the Medical Board. I'm chairing this meeting because the President, David Serrano Sewell, could not be here. I want to ask all of us to please turn our cell phones to silent and make sure they are off the table so we can avoid the feedback noise. You may notice board members accessing their laptops or tablets during the meeting. They're using the laptops solely to access the board meeting materials that are in electronic format. This is an official meeting of the Medical Board of California. As such, disruptions of the board business will not be tolerated. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct himself or herself in such a manner that permits the board to transact its business. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, please press star 1, you will hear a tone indicating you are in the queue for a comment. If you change your mind and do not want to make a comment, please press the pound sign. Assistance is available throughout the teleconference meeting. To request a specialist, press *0. Each person will be limited to 3 minutes per agenda item. During the agenda item 3, public comments on items not on the agenda, the board has limited the public comment period for individuals and the teleconference to 20 minutes. In addition, public comment from the individuals here at the meeting will be limited to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During public comment on any other agenda item, I want you to listen to this carefully because we did have committee meetings on. So, during public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Business services staff will be assisting me with receiving the public comments via teleconference during this meeting. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking an action on any agenda item. If for some reason I forget to ask the public comment on an agenda item and you wish to speak on that item, please raise your hand and you will be recognized. I would like to request all speakers complete a presenter slip so I can call you by name at the appropriate time and the record of this meeting can be full and complete. However, this is voluntary. Please give the speaker slips to Ms. Toof. Okay, thanks. Ms. Toof, she did already. I'll do my best to call upon everyone who has supplied a slip for the agenda item and recognize those who wish to make last-minute comment. I want to remind all speakers to please stay on the topic and keep your comments to 3 minutes or less. We plan to end today's meeting at 6 p.m. I'd like to introduce, Kim, can you please introduce? Okay. I'd like to call the meeting to the order and ask Ms. Toof to please call the roll call.
Dr. Bolat. Present. Dr. Bishop.
Here.
Dr. Gonadev.
Oh, here.
Dr. Hawkins.
Here.
Dr. Kraus.
Present.
Dr. Levine.
Here.
Dr. Lewis.
Present.
Ms. Pines. Ms. Shipsky. Here. Ms. Wright. Here. Ms. Yaroslavsky. Present. Dr. Yip.
Present.
Mr. Serrano-Sewell. We have a quorum.
Thank you. The quorum is present. I'd like to remind the members again that we will be taking a roll call vote on all action items. Moving to the agenda item 3, public comments on items not on the agenda. I have one speaker, Edward Barrera, Consumer Watchdog. Mr. Barrera.
My name is Edward Barrera, Consumer Watchdog. Forgive me for my indulgence in that I'm not available tomorrow. I just wanted for the Consumer Watchdog strongly supports the idea for doctors who are on probation to notify their patients. We believe that if there's, if you're talking about 500 doctors who are on probation, and you have 100,000 doctors out there, you should be in front, and there's no reason for why all doctors should be smeared by the few doctors. That's all. Thank you.
Thank you, Mr. Barrera. Any other members in the audience who has public comment? If not, anyone on the phone?
No one on the phones at this time.
Thank you. Okay, so we're going to the agenda item 4, approval of minutes from the July 30/31, 2015 board meeting.
I move to approve.
Second.
Any discussion? If not, roll call, please.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
I'm sorry. You gotta,
You have to do public comment.
Any public comment on the agenda item and the minutes?
Phones.
Any comments on the telephone?
Any phone callers, Amber?
No phone callers at this time.
Thank you. Roll call again, please.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Yes.
Ms. Yaroslavsky?
Aye.
Dr. Yip?
Aye.
Dr. Gonadev?
Aye. Thank you, Ms. Stoof. The minutes are now approved. I am now moving to agenda item 5, board communication with the interested parties. Dr. Levine.
Yes, I had approximately an hour conversation with representatives from Consumers Union about the administrative petition we'll be hearing about tomorrow.
Thank you. Ms. Yaslowski.
Same as me.
Dr. Hawkins. Dr. Kraus.
I had email correspondence with Consumers Union.
Ms. Shipsky.
I had verbal conversation with them.
Thank you. As usually, I almost say this every meeting, I do meet people from CMA, people from AMA, and people from many other entities because I do participate in many discussions, but we will not be talking about medical board issues. Just want to make sure that you're well aware of. Is there any public comment from the audience? Are there any comments from those on the phone?
No phone callers at this time.
Thank you. Moving to the agenda, item 6, update from the Public Health, Education, and Wellness Committee, Dr. Lewis.
Thank you, Dr. Ganadev. The Public Outreach, Education, and Wellness Committee met earlier this afternoon, and this was my first time chairing this committee, and I'm pleased to be taking on this new role. The committee's name has also changed, and its mission will now include overseeing the board's public outreach in addition to physician education and wellness. The first agenda item the committee discussed was the elements of a successful physician health program. The committee first, reviewed the uniform standards for substance abusing physicians. Any physician health program would need to comply with the uniform standards. For background, the board staff did meet with consumer groups such as Consumer Union, Center for Public Interest Law, and physician groups such as CMA, the California Society for Addiction Medicine, and Pacific Assistance Group. In September, to obtain each group's recommendations on what elements a successful physician health program should include. Board staff took recommendations from each group and in addition include some other recommendations of their own. The board staff recommended specific elements which were included in the PowerPoint presentation, and they are under the tab 3 of your committee packet. The committee members had a very thorough discussion on staff's recommendation, and there was some very thoughtful public comment. The committee did approve the staff recommended elements. It is important to mention that the committee does not believe that the board should sponsor legislation to create a physician health program, but if legislation is introduced, the board would want the legislation to include these board-approved elements. The committee is asking the board to approve the committee's recommendations for elements of a successful physician health program. May it please have this motion?
So moved. Second.
Any discussion from the board? Oh, that's very quiet. I have 6 slips, so please stay within your 3-minute period. So that's about 20 minutes. So we are, even though an item is only 10 minutes, we are going to take all the comments from audience who are here. You took this much time to come here, so we're not going to just stop at 10. The first one is Marian Hollingsworth.
Hello, my name is Marian Hollingsworth. I'm an advocate with the Consumers Union Safe Patient Project. I did give this testimony to the committee, and I'll give a part of it to the full board as well. While I applaud the board's efforts to educate the public in how to look up a doctor, there are a number of problems with many areas in the whole process, particularly in the call-in numbers, for those who do not have access to computers or know how to use them. And I'm here to tell you that the system is really unreliable. The first time I called in, the employee hung up on me when she couldn't find the name I gave her. The second time, the employee could not find the doctor and put me on hold for at least 10 minutes. Then a recording came on asking for the doctor's medical license number, which I didn't have, because if you can't find the name, you can't find the license number. I did leave a callback number, but was never called back. No, I admit I did test these people. This doctor uses a different name in his practice and with his patients than he does with the medical board license. It's actually very clever on the doctor's part because it makes him or her more difficult to find. If there's any slight deviation in the name or the spelling, a doctor is not very easily found on Breeze at all. And this is confusing for consumers and apparently also for the medical board employees who are supposed to help us look this up. Now, a number of doctors do this, and I can give you other names if you wish. Also, when I was on one of these calls, I referred to the site as Breeze, and I was...
Hollingsworth, I hate to interrupt you, but I think your comments are for tomorrow's item more than today's.
Well, this is for if you think it is, then, okay, I was told to comment on the...
I mean, you have appropriate comments, but I think it fits really well for item tomorrow, which is coming up.
Sorry, but I think she's commenting on the update.
It was on the update for that, so...
You're fine.
Okay, all right, thank you. As I was saying also on one of these calls when I referred to the site to the medical board employee as Breeze, I was told that this is not for the public use, but rather for doctors to change their records. And I really didn't know how to answer this. The bottom line is the call-in system is no more effective than the Breeze website itself. The only reliable way for consumers to truly be informed is for the medical board to require doctors to tell their own patients of their statuses themselves, whether they are in good standing or whether they are on probation. It's much cheaper and much more effective. Thank you.
Thank you. I just want to remind everyone that this motion is only on the physician health program. The rest of the report will have a motion afterwards. So please try to limit your comment to the physician health program. That's what I was trying to say. Next one is Julie D'Angelo Felmuth. Julie.
Good afternoon, Dr. Gunadev. Julie D'Angelo Felmuth from the Center for Public Interest Law. So it's my understanding that the committee is recommending to you a set of parameters or elements of a physician health program if some other outside group sponsors legislation to create such a program. And those elements are contained on these 2 pages, which are entitled Board Staff Recommendations. And I take it that the board will oppose a bill that does not contain all these elements. You don't have to respond to that. I submit to you that several critical elements are missing or not addressed or are inconsistent with the uniform standard, so I would like you to consider a few changes to these. First, other pages of your staff's PowerPoint presentation clarify that any new program will have to comply with the uniform standards. But that requirement is not on these 2 pages, and I would ask you to add it to those 2 pages. Secondly, on page 4-16, the second bullet says the program should be run by a private contracted nonprofit entity. I respectfully suggest two additions. First of all, this board should require that that entity be contracted through a competitive bidding process. Secondly, no organization or individual who was connected to the prior diversion program should be allowed to bid on this contract. I've told you before that the California Medical Association has created a nonprofit that is directed largely by individuals who were on the liaison committee that oversaw the board's prior diversion program for 24 of its 27 years. That liaison committee sat there and did nothing in response to the detailed numerous findings in 4 failed audits. The committee did nothing. I suggest to you that that proves they really don't know how to run a program that protects the public, and they should not be allowed to bid on the contract. During one of CMA's prior attempts to recreate a diversion program, it was the Steinberg bill in approximately 2012, this board took the position that no one connected with the prior program should be able to direct or be in control of any new program, and I would ask that you follow that same lead of your predecessors. Bullet 6 on page 4-16 says, report to the board any physician who is terminated from the program for any reason. That is actually inconsistent with the uniform standards. Uniform standard number 16 says a vendor must report to the board any major violation as defined in uniform standard 10 within 1 business day. A vendor must report to the board any minor violation as defined in uniform standard 10 within 5 business days. So it's not just terminations from the program that need to be reported to the board, but violations, non-compliance with the contract. Regarding bullet 4 on page 17, sufficient resources to perform clinical roles, blah, blah, blah. I told you earlier that at no time has there ever been a detailed financial analysis of either your prior program or of any of the other programs proposed in any bill after 2007. That must be done. It has never been done. As Dr. Gunderson told you from Colorado at your July meeting,
Please conclude.
Thank you. Don't do a PHP if you can't fund it. Underfunding a PHP is very dangerous. I have 2 other additions that I would ask that you look at, but bottom line, these 2 pages do not address the issue of confidential participation, which is a very legitimate issue. Many consumers have been injured by physicians who are confidentially participating in the diversion program. They testified to this board in 2007, and in my view, this proposal is not cooked until you deal with that issue. Thank you very much.
Thank you, Julie. Next one is Edward Barrera.
Thank you. Edward Barrera from Consumer Watchdog. I'll make it short because I also gave some information to the committee. And I know this is a legislative framework, but the logical conclusion is that a program is going to come down the pike. It's, every couple of years, there's another piece of legislation to create a program. I just want to make sure that the medical board, and you've done this in the past, the medical board should not support any program that lets doctors keep their addiction problems secret and avoid consequences when they fail. That's it. Thank you.
Thank you. Next one is Steve Alexander.
He needs a preface to sitting down here, I think, for everyone that's sitting around this table. In all due fairness, he's blushing now, but Steve Alexander is a former president and chair of this board, the Medical Board of California. For many years served under his leadership, and I have no idea what he's going to talk about, but it's good to see you again.
Well, the first thing I'm going to talk about is say hello to you. Thank you, Barbara.
I'm the only one that will remember you, I'm sure.
Appreciate that. Number one, I don't believe that former medical board members or any board members on any board should appear before a successor board. I believe it creates an awkwardness and a discomfort. So it's taken a lot for me to be here today. And though I'm uncomfortable doing it, and some of you may be uncomfortable doing it, I'm driven by a passion for good public policy. I'm a psychotherapist by training and have actual training in alcohol and drug addiction related issues. I also include amongst my clients organizations like Kaiser Hospital, UC San Diego Medical Center, Scripps, Rady Children's Hospital, Barnes Jewish Hospital, BJC Healthcare, St. Louis Children's Hospital, the Goldfarb School of Nursing, and the Salk Institute. And I've trained hundreds of physicians and surgeons on how to speak publicly, work with boards, and develop good public policy. I was, as Barbara said, an 8-year member under 2 governors, and I also served as the chairman of the Behavioral Sciences Board, along with, don't ask me how or why, the California State Athletic Commission. A lot of my belief, again, is in good public policy, and so I want to talk just briefly about my background and relationship with the issue of what is technically and appropriately referred to as diversion from discipline, not diversion. I sat on and sat in a diversion group here in San Diego, ironically in my old private practice, and I have a great deal of affinity and support for people who do seek help for mental health and mental health related issues, drug addiction, and whatever it may be. But what started my concern for this issue is when we, as a board, saw a presentation by a fellow from Florida that showed a physician who was in their secret diversion from discipline program who managed to break into the locked cabinet with the controlled substances. The last slide of which, Barbara, you might even remember, was the shot of that physician with a needle stuck in his groin, dead on the floor. Those are the kinds of things that sort of inspired us as board members to take action on what we learned from several audits that Julie D'Angelo Felmuth just pointed out, actually pointed out to us that we were incapable of monitoring our own program and were doing damage to not only the public, but to the physicians in the program who were able to scam the program by falsifying, for example, urine tests and things of that nature. So I'm here today to tell you I would strongly urge you to consider the action of that prior board, which was a unanimous decision by all, I think at the time we had 21 board members, to defund that program and end the secrecy that had transpired prior to that. And the compelling issue for me was simply that any one of you could have a daughter, a sister, a mother, a brother, a cousin, who you would have loss of life as a result of a physician intervention while under the influence. And you would have to explain to those relatives why that person died and why you as a medical board never knew, because you as board members do not know that that person was operating under the influence and within the secret program that the board sanctioned and funded at the time. So again, from my perspective, having served in your position, and believe me, it's much easier to be out here than it is to sit up there where you are, from my perspective, everything in my career as a psychotherapist and as a conscious human being says, this is not the place for those programs.
This is awkward, but please conclude.
Thank you. I knew you were coming. I could see the watch. Our business is consumer protection. If you look at the mission that we wrote when we were doing the strategic planning process, it was crystal clear. And it's those loved ones that I talk about, that I hear about and see about and learn about, that drove us to make the decision that we did. We are an enforcement body. We were an enforcement body. You are an enforcement body, and should not be in the business of sanctioning a program that's secret or which you fund. The people who need help will get help, and you often hear the rumor about it's going to drive people underground. Well, I think it was about 7 years ago that we did this, and I don't see any statistics to that effect. So again, I apologize for appearing here. It's not by my desire, it's just by my compassion for what I believe in is good public policy. And if I could end with a quote from Michelangelo, who said, "The problem isn't that people aim too high and miss, it's that they aim too low and achieve." So on behalf of the consumers of the state of California, I hope you aim very high today. Thank you for the privilege.
Next one is Beverly Edwards. Miss Edwards, you say you have it as item 7. I gather you want to talk on item 6. Can you? This is the item. If it is, please come on up. Okay, thank you. Marshall Montserrat Ramos.
My name is Michelle Montserrat Ramos. I'm here on behalf of Consumers Union Safe Patient Project. I first became familiar with the issue of substance abusing physicians in 2007 when the failed, now terminated confidential physician diversion program was up for sunset review. You may ask, why would such a confidential program be of interest to me? Well, my fiance, Lloyd Montserrat, died at the hands of a cocaine-addicted physician. Lloyd was a California political leader whose life was taken at 36 years old because his path crossed with a physician who had a problem with crack cocaine and earned a long arrest record, all while he held a license to practice medicine in California. You see, I should have known that Lloyd's doctor had a drug problem, a long arrest record, and a long list of victims. That information should have been available to me when I checked his physician's profile before Lloyd entered the hospital. But guess what? That information was not available. Why was this information not available? Because there was a confidential program in place that allowed doctors to practice with issues with drugs and alcohol, and Lloyd, I, and California consumers were not allowed to know. So Lloyd died, dead at 36, and Lloyd's doctor continues to practice. You call that consumer protection? I think not. I stand here to tell you that we will not support any kind of program that is confidential. Kim was quoted this week stating that the medical board wants you, me, to be an informed patient. In order for us to be informed patients, you cannot support any confidential programs of any kind. Now, I know it was stated earlier that this is merely a conversation and there are no plans to open a program tomorrow, but we all know that it's not a matter of if legislation will be pushed forward, but when. Your predecessors terminated a confidential program stating to hide something from consumers, something so blatant, it's unconscionable today. How could each of you think that somehow it's the right thing to do now to hide something so unconscionable from consumers? The uniform standards have only been fully adopted and placed into regulations for 3 months, since July 2015. It took fighting you for years to get you to follow the law and place those standards into regulations. In dealing with substance abusing physicians, you must give the uniform standards time to work before putting in place any new system that might interfere with them. There is nothing now preventing doctors from seeking such treatment with complete confidentiality. There is no need to create a special program that may interfere with the oversight responsibilities of the board. As your physician predecessor stated, the public now demands transparency. Why should doctors be protected in secrecy when consumer safety hangs in the balance? Again, it is time to now protect consumers. Thank you.
Thank you. Next one is Karen Miyato.
Thank you. My name is Karen Miyato. I'm an addiction psychiatrist at UCLA, and I'm the chair of the medical staff well-being program at UCLA. I'm very concerned that the question has been posed that if the medical board does not address or endorse a program, that somehow the public will be safer. As a treatment provider, I can't even wrap my mind around those thoughts, because treatment is what makes people safer. Physicians need treatment, and we need to know that that treatment is being monitored and overseen, and it's quality treatment. So I appreciate your efforts to look into this such important issue. Thank you.
Thank you. Any other public comment from the audience? If not, comments on the phone?
No callers in the queue at this time.
Thank you. I'd like to have Ms. Kirschmeyer to comment on a few things brought up.
I just did want to ask Dr. Gonadev if I could just take a moment to make sure that everybody knew it was the 2 pages of the board staff recommendation, but it also is the uniform standards that was part of that discussion, and those would also have to be included in any program. And just in regards to Ms. Felma's comment about the contradiction, there are 2 different items, and the one is the item that's in the uniform standards. They would have to report any violation to the board. That's part of the uniform standards already. But what we also wanted to put forward was that if they're terminated for any reason, they would have to be reported to the board too. So it's not in contradiction, it's actually on top of each other. Both would have to be done. So I just want to make that clear that everybody knows that.
Thank you, Ms. Kirschmeyer. Any comments from the board? Ms. Stoof, roll call, please.
Dr. Bolott? Aye. Dr. Bishop? Aye. Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Yes.
Ms. Jaroslawski?
Aye.
Dr. Yip? Dr. Gonadev?
Aye. Thank you. Dr. Lewis, can you finish the rest of your report, please?
Yes, I will. The committee also heard a presentation from the board staff on the board's Verify a License campaign and the board's outreach plan. Copies of this plan have been given to board members and are also on the back table near the door. The board staff presented a list of proposed outreach programs, including mall outreach that has already begun, public service announcements, including TV airtime, radio interviews, ads on billboards, mass transit, and working with various organizations to get the board's website information printed on things such as receipts, bills, paychecks, and the board staff has also proposed that the campaign be focused on March and that the board work to get March declared as a Verify a Physician's License Month. That way, the board can concentrate its outreach efforts on the month of March and hold the board's legislative day to get legislators involved. The plan also includes a timeline with activities to implement starting in this October, focusing many of the outreach efforts in March, but also includes ongoing outreach throughout the coming years. Committee members had a good discussion on the outreach plan and the timeline, and members here suggested that staff work on a process to prioritize outreach items and deliverables, and that the plan include this information in the future, and that staff develop a web page to explain the various license statuses and what information is available on the physician's profile and what information is not available, and that the staff consider revisions to Verify a License brochure, including making the board's website more prominent. And this concludes my committee update on the two agenda items. Thank you.
Is that a conclusion of your report?
That's the conclusion of my report.
So there is no motion here, but we have the remaining report of the Outreach and the Education Committee. Any public comment? I have one from Lisa McPepper.
Lisa McGiffert, Consumers Union Safe Patient Project. I talked quite a bit at the committee meeting, but I wanted to call your attention to the fact that we do support this outreach plan, and we're glad to see you doing it. We want to see it incorporated in the daily activities of the staff and not just a one-time campaign. Should be an ongoing responsibility, and that much of the work, and we'll continue to work with the staff and help in any way we can, but much of the work will be lost if you don't do it in plain language where consumers can understand. A very prominent example is Verify a License. Consumers don't know what that means. Make it more simple, look up your doctor, check out your doctor's background, whatever that, the average person would understand. And I think that will be very helpful. Also, you need to do outreach about your disciplinary orders better. People need to know how this relates to me. Why should I care about the doctor? Is there some issue that I should be concerned about? And you should communicate that in your in your outreach work. We look forward to working with you on this.
Thank you. We appreciate your comments, and staff already took the notes on your comments at the Outreach Committee, so we'll look into that. Item number 7, President's Report. On behalf of telephone comments on this item?
Amber, is there anyone in the queue?
There is no one in the queue at this time.
Okay, thank you.
Thank you. President's Report on behalf of Mr. Serrano Civil. I will read what he wrote. I want to thank the board and the committee for the work on the outreach program. We have seen a lot of positive and educational press over the last 2 weeks on how a patient can look up their physician. I believe this campaign is really going to make an impact on the patients in California. It reaches to the heart of the board mission of public protection. I hope all the members really make education of the board on their top priorities when they're talking to their friends, co-workers, and associates. I'm excited that this campaign will again take us to the Capitol for another legislative day. We have a lot of work to do over the next few months, and I look forward to working with staff and members on this outreach. Under tab 7 is the updated committee roster. I think board members have seen. I want to take a moment to thank Barbara. Me too, not just Dr. Serrano Sewell, for her service on the Education and Wellness Committee. She served as the chair of the committee for several years. She has led the board in numerous activities via the committee, and her dedication to be commended.
Am I being retired?
No, you are not the chair anymore.
Oh, that's so.
That's what Dr. Serrano, Mr. Serrano Sewell meant. I don't want to give him a doctorate degree yet.
Maybe somebody know. Me too.
As you will notice, we have made some changes to the committee's memberships, as well as renamed the Education and Wellness Committee to the Public Outreach Education and Wellness Committee. If any member would like to change their committee assignment, please feel free to contact Mr. Serrano Sewell or Ms. Kirschmeyer. Are there any questions from the members? Dr. Hawkins.
Do we have any numbers about consumers going to the website and inquiring about physicians that verify consumers? Are we keeping those numbers?
We can get those numbers to you. I believe they're in Ms. Hawkinson's report. We usually put how many have hit the web link, but we'll make sure that we get it over the last year.
Yeah, one other report from actually Panel B. Panel B elected a new chair. Thank you. I'm thrilled to be not to be chair anymore. Dr. Howard Cross is the chair, and Michelle Bollard is the vice chair. That's the only change from what's on the paper. Any other comments from the board members?
Oh, well, Panel A elected their chair and vice chair, and they're going to remain the same as they were for last year. Ms. Wright will be the chair, and Dr. Lewis will be the vice chair.
We are encouraging Panel A to finish in time, so thank you.
Excuse me, Panel A was finished before 12 o'clock today. Excuse me? Dr. Gonadab?
Any public comment?
Mr. Alexander, things don't change. The more they change, the more they stay the same.
And a public comment on item 7.
Yes, we do have a comment from Beverly Edwards. Ms. Edwards, please.
Good afternoon. Okay, my name is Beverly Edwards, and I'm here on behalf of Consumers Union Safe Patient Project, a nationwide campaign that is organizing patient safety advocates from across California as the California Safe Patient Network. We have reviewed the roster of NBC standing committees as of September 2015, and we appreciate all the work that the committees are doing, but we are concerned to see poor representation by the board's public members on a few of the committees. In particular, we see that the ratio of public members to physician members is only 2 to 5 on the board's powerful executive committee, and only 1 public member to 3 physician members on the board's important enforcement committee. The legislature requires that the medical board itself be composed of 8 physician members and 7 public members, nearly a 50-50 split. Certainly, in the requiring of this legislature intended that the board's business be influenced by a balance of physicians and members representing the public interest. We urge the board to revisit its committee compositions with the aim of having them reflect nearly 50-50 physician versus public member split of the board itself. Thank you so much.
Thank you, Ms. Edwards. There were 2 public member vacancies, and the governor just appointed 1 person. Any other comments from the audience?
Any comments from the phone?
Amber, are there any comments?
No comments or questions on the phones.
Thank you. Now we go to agenda item 8. Ms. Kirschmeyer.
Good afternoon. I would like to begin by asking for a motion to approve the orders following completion of probation and orders for license surrender during probation.
So moved. Second.
Roll call.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Yes.
Ms. Yaroslavsky?
Aye.
Dr. Yip?
Yes.
Dr. Gonadev?
Aye.
Thank you.
As Dr. Gonadev stated, we do have a new board member who was just appointed yesterday by the governor into one of our public member slots. Her name is Christina Lawson, and unfortunately, due to the short time frame of her knowledge of her appointment, she wasn't able to make the meeting today, but she will be at our January meeting, and so we look forward to meeting with her and having her on this board. So I'll not be going over all of the administrative summary or the licensing or enforcement summaries unless someone has a question. However, I do have a few items I'd like to provide an update and also some items to bring to your attention. The first item is that at this time, the board vacancies rate is only 4% if you look at the individuals who are actually in background or waiting to be appointed. This is the lowest rate we've seen in several years. We are glad we're filling positions and hope that it will make an impact in our licensing and enforcement functions. And I just want to thank our managers and staff for really moving those positions to get them filled. I would also like to point out for those not in attendance at the Enforcement Committee that we are currently working on the vertical enforcement report that is required to be submitted to the legislature on March 1st, 2016. As you know, we moved the date from 2015 to 2016 due to the transition of the investigators. I'm very happy to inform you that Ms. Anita Scurry will be assisting Ms. Robinson on the drafting of the report. We have already held one meeting with the Department of Consumer Affairs and the Attorney General's office to discuss the report. The report has to be completed in consultation with these two entities, so we thought their early input would be valuable. Of course, our biggest issue will be the availability to obtain the reports. We have our staff working on this, and we're looking to hire limited-term positions to assist in report writing. I will be working with Mr. Serrano-Sewell to identify 2 members to work with staff on this project. It will probably be Dr. Yip as the Enforcement Committee Chair and another member. This report will be looking at the effectiveness of the vertical enforcement program and identifying any recommendations for improvement. I also wanted to let you know that last week we received the Attorney General's opinion on medical assistance. As you may remember, in October 2013, the board approved staff to request an AG's opinion on whether a medical assistant could perform basic pulmonary function testing such as spirometry. The board had been contacted by the Respiratory Care Board stating that they were of the opinion a medical assistant could not perform these procedures. Therefore, in collaboration with the Respiratory Care Board, we requested an opinion. The opinion received states that a medical assistant may lawfully perform spirometric pulmonary function testing if the test is a usual and customary part of the medical practice where the medical assistant is employed and the requirements for training, competency, authorization, and supervision are satisfied. Board staff will be completing an analysis of the opinion and will update the board's website as appropriate based upon this information. I will also provide a copy of the opinion to the members next week. Also, on October 23, 2015, the board received a letter from the Bureau of State Audits. The letter informed the board that they were conducting an audit pertaining to the oversight and monitoring of children in foster care who have been prescribed psychotropic medications. Therefore, the Bureau will be auditing the responsibilities of the medical board in this area. As was stated earlier in the Enforcement Committee, we have a meeting set up with a pediatric psychiatrist a week from Monday to discuss the information we have received. We are hoping that she can either assist in the identification of physicians who may be inappropriately prescribing, or that she can assist in identifying additional information we need to obtain from the Department of Healthcare Services and the Department of Social Services. In regards to a CARES update, I would like to first state that AB 679, which just passed extended the CARES registration required date from January 1st, 2016 to July 1st, 2016. Therefore, physicians have an additional 6 months to register for CARES. In addition, I would like to point out that the information under BRD 8B3 is not correct at this time. At the time I had written the report, we were under the understanding that the streamlined application process would be available October 30th for all users. The intent at that time was to redirect users into either CARES 2.0 or CARES 1.0, depending on their browser, whether it was a compliant browser or not a compliant browser. While DOJ is working on this redirection ability, it will not be available until late November or December. Until that is available, users will need to continue to register by using a notary. When the new streamlined process is available, we will be sure to notify all physicians of its availability and post information on our website. The Board, Department of Consumer Affairs, and Department of Justice all recommend physicians implement an update to their systems in order to use a compliant browser for CARES 2.0. This allows physicians to take advantage of the improvements and alerts that are available in the new upgraded system. Lastly, as stated in my written report, I want to let you know that the inaugural meeting of the Interstate Medical Licensure Compact Commission was held in Chicago Tuesday and Wednesday of this week. 11 states are now part of the commission, and more are in the process of approving legislation. The meeting was held to begin the process of establishing the roles and duties of the commission, commissioners, and each state. In addition, they established working groups on planning, finance, and rules. At this time, the board has not been approached by any legislative offices inquiring about legislation on this compact. The Federation has also sent a notice that the Federation of State Medical Boards, also sent a notice that they are seeking resolutions by February 26, 2016 for their annual meeting. If any member has any resolution they would like to put forward, please contact me to discuss your idea so it can be developed and presented at the January 21st and 22nd board meeting. The Federation is also seeking nominations for elective offices, and I did send this information out to all members, and at this time, no member has shown interest in an elected office. The Federation is also seeking individuals serving on committees, and again, at this time, I haven't received any information on that, so I don't think we need to vote on that at this time. That concludes my report, unless there's any questions.
Thank you, Ms. Kirschmeyer. I do want to point out, actually, I want to thank Kim for dealing with these children, foster children, with the medications. It's not just a medical board issue. It's social services, it's Department of Healthcare Services. We need to make sure that those agencies provide appropriate resources so that these kids are taken care of. Just punishing doctors alone is not going to solve problems. So this is one place where I think medical board took the leadership and worked with all these agencies. I'm really thankful, Kim. Really appreciate it. Any other comments from board members? Any public comment? Okay, actually. Genevieve, please come on. We actually appreciate you dragging yourself to these board meetings. It's not easy.
Well, I try very hard. I think that's what kept me alive, to be so honorary. On the cure system, I have been opposed to that system from day one. And I am very concerned because it's still not up to date. Actually, I went to a session given by the Board of Pharmacy of California 2 weeks ago. And I was amazed of the wrong information given by the DEA and so on. And that's of great concern. I mean, CURE have not been an appropriate system. It's lousy software. And it still does not communicate with 33 states. So, I mean, to see all that money invested and, like I said, many times even given the wrong information, and all the inappropriate journalism having to do with opiate overuse and so on is of great concern. Specifically that the CDC 2 weeks ago came out showing that the state of California in particular has the least buying or prescription of the opiate of any state in the United States. So I'm getting very tired to often get the wrong information, because now you have a lot of physicians, including pain specialists, who are scared to prescribe the appropriate medication to their patient. So I think before you regurgitate newspaper article with the wrong information, you do your homework, not you in particular, but the homework is done and shows the actual situation. I'm glad to see that Governor Brown postpones the activation, a full activation of cure to June 1st of next year. But I think it's still a long way to be ready to be used. Most pharmacies do not like it. If you are too slow to enter a patient name, it kicks you out. Something needs to be done. That's a waste of time for everybody concerned.
Thank you. We appreciate your comments. We understand what kind of comments Cures 2.0 generates. In the end, it's a good intent, and one day we'll get there. Hopefully sooner than later. It's both for people who are suffering with pain and people who have addiction problems who need help. So that's all we're trying to do. Any other comments from the board? Not any comments on the telephone?
Any callers on the phone, Amber?
No callers on the phone at this time.
So, although Cures 1.0 is not perfect, as a practicing physician, I found it to be valuable.
Thank you. That's the shortest comment we heard today. Dr. Hawkins. I thought you wanted to go. Oh, they hear. Okay. I thought it was coming on the telephone. I said, gee, that was a very short comment. Thank you. Really appreciate your comment too.
Next time,
I'm looking there, and there, everywhere. So, next item. Item number 9, update on the Physician Assistant Board, Dr. Bishop.
That's quite all right. Okay, the 2015-2016 Sunset Oversight Review by the Legislature. The board staff was informed that the Senate Committee on Business, Professions, and Economic Development and Assembly Committee on Business and Professions will begin their Sunset Oversight Review in the fall of 2015. The Physician Assistant Board is scheduled to be reviewed. The board last was reviewed in 2012. The staff has begun preparation of the report, which is due to the legislature December 1st, 2015. The governor signed SB 800, the Department of Consumer Affairs Omnibus Bill. This bill made non-controversial or technical changes to various provisions pertaining to the healing licensing programs of the department. Among other things, the bill deleted the terms board chair and vice chair, replaced with president and vice president. The governor also signed SB 337 Pavley. This bill requires medical schools to reflect the supervising physician for each episode of care, requires a physician assistant who transmits an oral order to identify the supervising physician, recast medical record review provisions to require the supervising physician to utilize one or more mechanisms, and recast prescribing provisions to allow physician assistant to prescribe Schedule II controlled substances. The revised physician assistant application for licensure has been placed on the board's website. The application recently was updated to reflect recent changes in law and reporting requirements. Additionally, the new application is much more professional in appearance. On September 21st, 2015, board member Jed Grant and the board's executive officer attended a training session sponsored by the Department of Consumer Affairs regarding the North Carolina Dental Examiners v. Federal Trade Commission case. This case could have potential impact on the Department of Consumer Affairs, including the board. The case established a new standard for determining whether a state licensing board is entitled to immunity from antitrust actions. The board will discuss this case and potential impact to the board at our November meeting, which is this coming Monday. Word of thanks. I would like to thank the medical board, your executive officer, and staff for your continued support. We also appreciate your continued assistance. And as I stated, the next scheduled physician board assistant meeting is November 2nd, 2015. That concludes my report.
Comments from the board? Any comments from the audience? Yes, please come in.
Hello, Teresa Anderson, Public Policy Director for California Academy of PAs. I will fill out a slip, I apologize. I just wanted to provide one quick clarification on SB 337, and we are very happy that that passed. PAs can already prescribe C2 medications. This is about documenting, so it passed, the bill passed, and it really just increases options for documentation of that, of C2s. Thank you.
Thank you. Any other public comment from the audience? Comments on the telephone?
No comments on the phone.
Thank you. Moving to the item 10, update on health professions, education and foundation, Ms. Jarzowski and Dr. Yip.
Very briefly, they did a very good job in outreach, and they opened 6 cycles of loan repayment program, and so far 5,000 applications. So they've done a really tremendous job in outreaching. So Barbara and I are helping. So thank you.
Barbara? Thank you. Any comments from the board? Any comments from the audience? It looks like everybody is hungry. Any comments on the telephone?
No comments from the phone.
Thank you. That's it. Meeting is adjourned till tomorrow.